I'd call to order the September 7th, 2016 Sunshine Ordinance Task Force meeting.
On the call of the roll, Member Barnanetsky. I know I'm mispronouncing that. If you just say present.
Present.
And am I pronouncing that correctly?
That's correct.
Thank you. Member Eldon.
Present.
Eldon present. Member Josh Wolf.
Present.
Josh Wolf present. Member Copra. Copra absent. Member Tesfa. I have been informed by Member Tesfa that she will be delayed today if she is able to make it until approximately 7 o'clock. She is marked as excused at this time. Member Moss.
I'm here.
Moss present. Member Kanata.
Here.
Kanata present. Member Fisher.
Present.
Fisher present. Member Hinsey.
Present.
Hinsey present. Vice Chair Hyland.
Here.
Hyland present. Chair Wolf.
Here.
Wolf present. We have a quorum. Just a few items to mention. I did mention the Member Tesfa may be arriving late today. I'd like to state that item number 9, file number 16026, has been withdrawn by the complainant. I did receive that withdrawal yesterday. Yes, item number 9 by Michael Petrellis. Item number, that note is no longer valid. And I would like to state that file number 1650, item number 14, there's a possibility that the complainant may be delayed today due to a conflict of scheduling with another meeting, but he will be appearing today. I'd like to introduce Victoria, our newest member.
Thank you.
Okay. Yeah, thanks. Oh, thanks. Okay, so minutes.
Item number 2, approval of minutes from the Sunshine Ordinance Task Force, August 3rd, 2016 meeting.
Any comments, changes, edits, typos? Okay, nothing.
Oh,
Public
wait, sorry, I had a typo.
Yeah.
It's just my name is misspelled at one point. I don't know how big a
I
deal
will
that
do a
is.
search for that if you happen to know which page.
I do. It is on page 15. Oh, yeah, P15.
Okay, I will make that correction.
Perfect, thank you.
Let me take that on, I guess any of these minor typos kind of thing we can take on without objection. Okay. Let's get some public comment on the minutes. Seeing no public comment, let's call the roll.
On the motion to adopt the minutes as amended, Member Barnanetsky.
Yes. You can do it.
Aye. Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra absent. Tesfa excused. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay, let's call the second item, item 3.
I do not see Mr. Hepner in the room at this time. I did
Well, it's a
call his office.
chair's report.
Oh, sorry. My apologies.
Yeah.
Item,
3.
I'm just
Oh,
noting the time and I
Okay.
misplaced it.
Got it.
Item number 3, Sunshine Ordinance Task Force Chair's Report.
Okay, so I only have one item for today. This is in regards to a letter that was sent from the New California Media to the City Attorney's Office requesting to cede their nominating authority for the seat here on the Sunshine Task Force. The response from the city attorney was a denial of that because it was a vote by the voters of the city and county of San Francisco. It was their will. And so until there's a change or a revision or reforms or another vote by the voters to make that change, they will still continue to be that nominating authority. I put in a call to Ms. Close, who is the chair or the executive director. We've been playing phone tag, so we haven't had a opportunity to speak formally about it. To see if maybe we can rectify it. I would really enjoy having all 11 members, and to continue to have an even number of members is difficult for a chair in breaking a tie. So I'm going to continue to try and meet with Ms. Close on this and see if we can kind of move that along. And that's all I have for today. So if there's any public comment on that item.
Good afternoon, Task Force members. I'm Richard Nee, and I am quite familiar with the issue that Chair Wolf has raised. Sandy Close, the executive director of New America Media, is very, very favorable to sunshine. But New America Media's resources are stretched very thin, and she and her staff just doesn't have the time to do this anymore. Society of Professional Journalists Northern California has agreed to take on that nominating role, and as a matter of fact, I can tell you that sometime down the road, we're going to attempt to do that without bucking the without bucking the rules, without bucking the ordinance. We'll see what we can do about recruiting a nominee and vetting any nominees, and then taking that to New America Media and Sandy Close. So we just as you would like to see a full complement of the task force. I kind of disagree with the city attorney's interpretation. The Board of Supervisors has, in fact, passed legislation to amend the ordinance and may do so. When doing so will clearly further the letter and spirit of the ordinance. And the change that we are proposing, both New America Media and SPJ NorCal believe it would do that. However, for the moment, we are going to live with the city attorney's interpretation. We'll go from there.
Thank you. Any additional public comment?
Peter Warfield, Executive Director of Library Users Association. We, too, certainly would want to have a full complement of task force members. The recollection that I have is that the city attorney, and please correct me, the city attorney said basically that New American Media could, as it were, give SPJ the work of finding a nominee and then could propose that nominee as its own to the supervisors for approval on this task force, and I see the chair nodding. So I think the city attorney, in their response, incorporated a way for New American Media to at least nominally continue to fulfill its obligations while leaving the effort of recruitment and all that entails to SPJ. And perhaps the chair might elaborate on that if he feels like it. Thank you.
Members of the task force, Ray Harris, Director, San Francisco Open Government. I think that the prior speakers brought up some good points, and I really think that a little bit of imagination and ingenuity might be the answer. Maybe the Society for Professional Journalists can vet someone and then recommend them to New America Media, who might then give them an honorary position, a non-paid position on their staff or whatever that wouldn't require them to do any work for them, but would technically make them part of the organization and as a result fulfill the requirements of the law. But the most important factor is getting a full complement so that all of the intended people that were supposed to be on the task force are represented.
Any other public comment? So the only response I have to this, and I appreciate a former member need a step up at SBJ would be helpful in this matter, would just to make sure that if they do help New California Media in this endeavor, to make sure that it's someone who's representative of the kind of the demographic that this organization was intended to bring to the task force. Okay, let's move on. Members, any questions, discussion items? Okay, great. Let's move to item number 4.
Item number 4, file number 16060, report, Board of Supervisors, file number 160478, proposed amendments to the Campaign and Government Conduct Code requiring commissioners to file behested payment reports regarding the solicitation of charitable contributions over $5,000.
Okay, this is a continuing item, is it not?
Yes, it is, and I believe that Member Moss submitted some questions that are included in the packet. And
okay, so we're going to, I'm sorry, yes. No, that's okay. Okay, Mr. Hepner, thank you for joining us. Did you get Mr. Moss's questions?
We're probably going to have to, actually, if there's a spare copy of those questions, I just don't have them with me. My apologies on that regard.
Through the chair, there are quite a few. Just a heads up.
And I appreciate Member Moss taking the time to be very thorough.
I ask a lot of questions in general.
Less is Moss. No, sorry.
Chair Wolf, if I could address the task force briefly and just provide some updates on the ordinance and where we're at, that might be helpful.
Sure.
My name is Lee Hepner from Supervisor Aaron Peskin's office. Thank you, Chair Wolf and task force members, for having me back to discuss this ordinance, which is in the works. It's very much a work in progress. On July 15th, or rather on July 25th of this year, I appeared before the Ethics Commission with this piece of legislation as well. And at that time, it was in the same form, substantially the same form as it was drafting-wise as when I had it before this body. And just to recap, this is an ordinance that would require reporting by commissioners or members of boards, city boards, of solicitations or requests of contributions to charitable organizations, 501c organizations, over $5,000 or in a cumulative quantity over $5,000. And those would be quarterly reports and sort of encompassing any solicitation. We presented this to the Ethics Commission. The Ethics Commission approved this ordinance in spirit unanimously by a 4-0 vote with recommendations that I think are relevant to some of the concerns that Member Moss raises, also that were raised over the course of our conversation, I suppose about a month and a half ago. Those recommendations were that we limit the reporting requirement to those solicitations that have a nexus between the board member or commission member and the governmental duties of those volunteer officials and the persons from whom the solicitations are sought. That is to say, individuals who have some matter of business before the body or commission in question. And I think that was kind of raised here in the context of whether somebody who works works full-time for a nonprofit fundraising, and they're paid to do that, that's going to impose quite a burden if this is their day job, to report all of those solicitations, to the extent that it may impair their ability to keep up with that employment. So that's one concern that we internalized and understand. Next, the Ethics Commission and Ethics Department staff had concerns about their ability to implement this. It is certainly going to require some amount of new disclosures and posting of those disclosures and processing these disclosures, coming up with the forms for these disclosures. And in acknowledging that, we have sort of not officially, but at least expressed a willingness to support an appropriation for Ethics Department staff, and to push back the implementation date of this to January 1st, 2018, to allow some time for those aspects of the ordinance to be implemented. But returning to the first point, and I think that this is one where we're still deliberating how to address this, we are in talks with the City Attorney's Office right now to narrow the reporting requirement, to establish what that nexus is, to establish some nexus between the reporting requirement, or rather the solicitation in question and the interested party. And I think that that is going to be the tricky part, is how to define what an interested party is, how to define that nexus. Is this someone who has a contract before a city board or a commission? Arguably, yes, that's something more in line with what we're talking about. Is an interested party anybody who provides public comment for or against a project or contract at a city board or commission? That might be going a bit too far. That might be casting the net a bit too widely. So does this incorporate people who have familial or financial relations to a party seeking an entitlement before a city commission or board? That might be something that we want to consider. So the point there being, we could cast this very wide or very narrow, and I think the trick for our office right now is to really strike the right balance so that commission and board members do not have an inordinate burden, but we're still getting at the root issue, which is, are commissioners and board members leveraging their influence to seek solicitations or request contributions to charitable organizations in a way that might transcend what we think of as proper or allowable. So that's where we're at right now. We're still moving forward with this. Conversations ongoing with the city attorney's office, but we did hear your comments in that regard. We did hear the similar comments from the Ethics Commission about narrowing this reporting requirement to just those solicitations that are made of interested parties before boards or commissions. And with that, I'm happy to answer any questions. I think that may answer a number of questions that Mr. Mass raised. Will the raw data be publicly available? That is the point of this, would be for the public to be able to inspect these records. So, I'm happy to answer any specific questions to the best of my ability to do so at this time.
Members? Go ahead.
So, I mean, obviously, there's a lot of questions on here that would still like answered. I think that my main concern still is the definition of solicitation, and particularly an indirect solicitation, and how things will be handled with, say, just sort of broad expressions of support or broad requests on social media or things like that, where, somebody says, hey, there's a, emergency in Haiti. Everybody should donate to Red Cross, and whether that is something that is going to trigger it. If somebody who happened to see that tweet donated more than $5,000, and the person would necessarily know about it, and Red Cross wouldn't necessarily release that information. So that's just still my concern. It's not so much a question, but something that I would still like to see addressed in the ordinance.
And to address that, and I think I said this last time as well, I mean, the way I see it is, if you put out that sort of broad solicitation via Twitter or something to ask people to donate to the Red Cross, or to your own nonprofit, for instance. I guess with your, it's a separate issue. If they were donating to your own nonprofit, you ostensibly have access to the information of who followed through on that donation and contributed over $5,000.
I mean, not necessarily.
That may speak to my ignorance of how nonprofits operate, but beyond that, I think the overarching point is that by virtue of sitting on a city board or commission, you may need to adjust your behavior in the public realm, and that may involve not issuing solicitations like that broadly on Twitter. That may be the price of sitting on a public board or city commission. I don't know if that is an acceptable price to pay. That is for you to tell me if that's something that you can adjust. But my thinking right now is that there is an overriding public interest in having this information disclosable that I think sort of overrides the burden of having to adjust your behavior in that specific regard.
I mean, in my personal opinion, I mean, if somebody retweets, not even calls her, just retweets a Red Cross solicitation and they're facing criminal charges on that, because this is a piece of ordinance that does come with criminal penalties. I mean, that does seem like quite a significant, cost for serving as a volunteer on a commission.
Duly noted.
Just some feedback.
Of course.
Anybody else? I have a couple of comments. Something different that you said in this presentation than in previous presentations. One is you said that as being the fundraiser in the organization versus just being an employee.
I may have misspoken in that regard. I mean, I think what we would, that's going to be a question of the drafting, but I think it would be something more like staff person at a nonprofit who engages in fundraising activities. I don't know that we're actually exempting merely people with the title fundraiser,
Okay, but if it's like a person that does, is an office manager, not necessarily directly involved in fundraising in the organization, their name may not show up on a solicitation or a brochure or anything like that, versus a board member.
Right. Well, board members are frequently sort of honorary or volunteer positions that I don't think would be exempted by the ordinance. With respect to an office manager, if they are the individual engaging in fundraising, or if fundraising is, a substantial part of the duties that they perform at the nonprofit, I think it's a little bit easier to sort of exempt that individual, but I'm not really sure I understand.
So I think the intent of my is around the actual decision making. An office manager that cannot make necessarily a decision on behalf of the entire organization on a position or an action that it would take in relation to the intent of what this law is trying to do. This law is trying to capture as you're saying, like a nexus or a connection between somebody who would be soliciting funds, receiving that funds that may receive benefit from the city in some way, shape, or form, right?
In this context, is the office manager the board member or commission member? Or the city commission sits on a city commission? Or?
Right. If the office manager, just an employee, not involved in fundraising, was sitting on a board or commission.
Well, they would still have to disclose any solicitations they make over that dollar threshold of interested parties.
Okay.
Depending on, and again, then the question becomes, well, what is an interested party?
But by the same token, if it was a big company, how would they know? If it was a big nonprofit, how would they know that a donation would come in for the organization? I mean, they would have to have their hands on the actual donation, or the solicitation would have to, Because originally this sounded more like if you're soliciting and your name is on it and you're a board or commission member, then, okay, I can, I can see that. Okay, then donate to me, and then I'll make sure, something goes your way or not goes your way. But if I'm an employee that has no knowledge of how donations come in, where they come in, who they come in by, or anything like that, because it's a very large company.
Right, and then again, it sort of begs the question: why is an office manager who sits on a city commission soliciting contributions over $10,000? I'm not sure I exactly follow, or maybe that office manager should not be engaged in the solicitation of contributions over $5,000.
That's what I'm saying is that they aren't directly involved in solicitation at all. But their organization may receive donations in excess of the limit. But they have no knowledge of it.
I don't think that falls under a direct or indirect solicitation. I can check on that and make sure that interpretation is sound.
Okay.
But I mean, the clearest example of this, right, is a direct solicitation. An office manager who sits on a commission, who sits on the planning commission, for instance, says to somebody seeking an entitlement, "Hey, well, why don't you just donate $5,000 to this charity, and I'll see what I can do with you at the commission." I mean, that's kind of the clearest sort of example of the quote unquote evil we are trying to shed some light on.
Isn't there already laws around that kind of activity? Around, aren't there ethics rules around, extending favoritism of votes or decisions or what have you?
I know that there's not a disclosure requirement on that behavior, nor do I believe that it's prohibited to seek solicitations to charitable organizations. Not to my knowledge.
Okay, got it. Okay, very good. The other one was in one of the previous presentations, you had specified 501c3s. This time you specified 501cs. So are you...
That too may have been, I don't recall ever narrowing it to 501c3s. In fact, I think that there are other 501c organizations which were very expressly contemplated. So
okay.
Yeah.
And will this also include religious organizations?
Yes, I believe so. I mean, yeah.
Okay. And I also, just a comment, we need to also pay mind to the number of people that seek to and do serve on these boards and commissions, most of which are volunteer positions, that creating too many tight restrictions could limit that, and it's really hard to get people to kind of step up and serve on these boards and commissions. So
I think that's absolutely right. Not to interrupt you,
no,
but I think that this has been raised in the context of previous restrictions that have been proposed, ethics regulations. I think that that's in the back of our minds while we do this, and I appreciate that comment. I think that part of our willingness to narrow the reporting requirement to solicitations made to interested parties is a figment of us trying to make a really big step in reducing that burden. Or the specter of that burden. I don't think, though, that anybody would disagree that soliciting a contribution to a charitable organization is good or proper if you're soliciting it from somebody who is seeking favorable treatment at your board or commission, or who might be expecting that from you in your capacity as a board member or commissioner. So I think that, if we can strike that balance correctly and sort of prevent the situation that Member Moss is talking about and minimize the burden on people who work at nonprofits or other members of the public who voluntarily serve on boards or commissions, that's really the trick for our office right now. And I think that we completely understand that danger and are willing to work on it.
Very good. Thank you. Any other comments? Yes, Member Joshua.
So I'm still confused about what the procedure is or how this proposed law would deal with contributions that the requester was unaware were made. So the example of the tweet that generates a $5,000 donation to the Red Cross, but you have no idea that someone donated, or the religious example that Chair Wolf brought up of, let's say you're a planning commissioner and your pastor asks you to give a guest sermon. At the end of it, you're like, and be sure to tithe this week. And someone in that audience does have business with the city that's within your department, but you don't even know who put money into the offering box in the first place, or that any donations were over $5,000.
Yeah, and I think that that's a really interesting hypothetical, and frankly, I don't know that I have the best response. I think the inverse, or let's play it out. Say somebody sees that somebody received an entitlement or a beneficial or a contract approval or beneficial treatment for a board commission. A member of the public, completely separately of any requirement to report any contributions, recognized that, oh, wow, didn't that person just contribute $10,000 to Member Wolf's charity of choice? That seems like an odd thing. And then you would have to say, well, I did not know. How could I have known? I didn't solicit that. Why would I have reported something I had no knowledge of? So we could insert language that says required reporting of solicitations of people who the board or commissioner member knew or should have known had an item pending before the body, or that they only of contributions that they knew or should have known were made. It creates a really kind of interesting loophole or safe harbor for folks to say, even if they did know, even if they did make that solicitation, to say, well, I didn't know about it. How could I have known about it? It wasn't my business. They just did that completely independently. And then it becomes a very interesting question of he said, she said. So as a policy matter, do you create that sort of exemption? Do you create that loophole for people to, be able to couch their ignorance in? I don't know. Or do you err on the side of a stricter requirement and actually just expect your commissioners and board members to know that there are consequences to solicitations that they make, and rise to a higher ethical bar that may involve them changing their behavior in this, that, or the other, hopefully minor way. That's kind of the balance. And I respect the question, but I'm not sure that I have the best answer at this time.
Yeah, I just to expand on that a little bit, I think it's a little hard. Like, I would have to, if I go through my agenda 3 days ago that I just got, and I look and I see, so-and-so, and I'd have to actually go through almost the entire agenda and then go to my fundraising officer or fundraising person at my organization and say, is anybody on this list? Did any of them donate to us? And then in that 3-day time, which could be over a weekend, I would have to make that reporting before the meeting happened. Just to correct on that point, technically you would have some window after the meeting as well to make that reporting. So, but then if I was at a meeting and I made a decision that I probably should have been recused from, that my colleagues would recuse me from because there was an appearance or an actual conflict of interest at that point, which is part of the fiduciary responsibility and rules of being on any of these boards and commissions anyway. So I think you're just figuring out how the operation of this procedure works.
And I think it goes to your earlier question too about whether this underlying behavior that we're trying to get at is actually prohibited. I don't believe it is. Okay. So if anything, this sheds light on how this system works. Okay. So, people might call you out for it, maybe justifiably so, I don't know. But I don't think that it is grounds for, your dismissal from a board or commission. I think it's more of a public awareness, public knowledge, transparency.
Okay. Anything else for the good of the cause?
Make a motion to continue this pending, the answers that Member Moss had.
Okay, great.
And additionally, I'm happy to come back after we introduce this. To be clear, this has not been introduced. This is not, pending before the board anytime, particularly soon. I think that there's time for us to, meet again before final board approval, and I'm happy to do so.
Perfect. Thank you. Is there a second to the motion to continue?
I'll second it.
Moved by Vice Chair Hyland, second by Member Moss. Public comment on the continuing of this item. Seeing no public, okay, we have public comment.
I think this motion is a good motion, and I looked at it very carefully. I just, in this interim time while you're continuing it, can I just add one thing which has been very shocking for me to understand? When someone sits on a board and commission in the city and county of San Francisco, there is a requirement that they be sworn in, that they take the oath of office, and that it be filed with the county clerk. And every time they're reappointed, that same process is supposed to take place. This is the San Francisco City Charter. This is the an assembly bill which was amended in 2015 to assure this kind of thing happens, and it's part of the California Constitution and 2 city attorney opinions. And I think that there needs to be some follow-through in this endeavor, because there are many people who sit on boards and commissions who have not been sworn in, and technically under the eyes of the law they are not allowed to hold public office.
Members of the task force, Ray Hartz, Director, San Francisco Open Government, and this is basically something that I think is kind of a question to Mr. Hepner. My real concern has been for a long time relating to some of the entities such as the Friends and Foundation of the San Francisco Public Library and their relationship with the public library, raising money, essentially selling the name of the library for profit, and doing so in active ways. In other words, they give the Friends the right to use library facilities to hold the Imbibe program. They contribute millions of dollars worth of discarded city property to the Friends, which they then sell and retain the money. They hold constant fundraisers where all the commissioners attend, and I have to understand, having been to those myself, that part of why they're there is to solicit funds from donors for the Friends, which is then ultimately going to supposedly benefit the library. I know from my own study of the relationship between what they raise each year and spend each year and what the supervisors authorize them to contribute to the library. They give about 6 cents out of every dollar to the library, when I think most members of the public think that the majority of the money is actually going to the library, where 94% of it, from what I can tell, is going to fundraising and to support the existence of the Friends. So if we have those kinds of relations between the commissioners, I think the most egregious part is not what I know, it's what the library commissioners don't know. They have no idea what the Friends actually give to the library. They're out there actively soliciting on the behalf of the Friends, helping them raise money, putting out this what I call a lie, a fraud, that this money is going to benefit the library, when they actually, if you ask for public records requests, have no idea. They never get any reports. In fact, the last time they came before the Library Commission, they had not appeared for more than 40 months. And so basically the library and the Library Commission have no idea where this money is going. And I think that is a lot more egregious, because we're talking, since 2000, more than $80 million that has passed through their hands. And as I said, about 6% of that is actually going to benefit the library. So, we can talk about small, $5,000 or whatever, but when we're talking about $6 million plus a year, I think that's something that ought to be in this law, and I'm not sure exactly where it does fit.
So, Mr. Hartz, you support the motion to continue this item?
Yes, I do, but I was hoping that when it is continued that I might get an answer at the continued meeting.
Thank you. Any other public comment? Seeing none, please call the roll. Or actually, this is kind of procedure. We can pass it by
An objection?
a regular call of the vote. I'll just call if there are any objections to continuing this item. Okay, seeing none, the motion has passed by acclamation. Okay, let's move on to the next item, please.
Next on the agenda is file number
Thank you, Mr. Hefner. He took off. Okay, sorry.
14095, complaint filed by Bob Planthold against Supervisor Malia Cohen and Supervisor Scott Wiener, Board of Supervisors, for allegedly violating Administrative Code, Section 67.7 and 67.15A, and California Government Code Sections 54954.2 and 54954.3, for failing to provide adequate opportunity for public comment at the Land Use and Economic Development Committee meeting of September 15, 2014, and September 29, 2014, and the Government Audits and Oversight Committee meeting of September 11, 2014. On June 1st, 2016, the task force heard the matter and requested that the respondent provide information as to whether or not the determination was made regarding amendments to legislation being substantive or not, and how the public was informed of the determination.
Okay, so is the respondent here?
Is there a respondent here in the room for this matter? It does not appear to be one at this time.
So the only response that we have is the one that I think I requested of the clerk to describe whether this was substantive or not, and what is considered to be substantive, which we did get communication on, I believe.
We have one additional communication on page 26, dated August 18th, from Supervisor Wiener's and Supervisor Cohen's office.
Okay.
That's the one that appears at the top of the package, is that right?
Right.
Electronic package. It is, yeah.
So, at the bottom of this letter, there's says there's an attachment from Deputy City Attorney John Givner dated October 15th. Is that the following page on page 28? Okay, got it. Just want to make sure. Okay. Okay. Wait a minute. So that's, wait a second. The notation, the footnote says letter from Deputy City Attorney John Givner. The letter after is from the Board of Supervisors, and it's signed by 3 supervisors.
Right.
So is there a letter from John Givner? From DCA Givner?
I will take a close look and let you know shortly.
Okay. And I believe starting on page 34, it's actually, that's just the response letter, but page 85 is a memo from Ms. Angela Cavillo from the clerk of the board, the clerk of the Board of Supervisors. Okay, so we're going to pick up here. This is now before the members. So if you have any additional comments or questions for the complainant on this matter, we'll give the complainant some opportunity to offer some rebuttal. Okay. Mr. Planthold, why don't you provide us with, if you have rebuttal.
What is your timeline or time limit, please?
I'm inclined, well, since the
Is it 3 minutes or 5 minutes for me?
Oh, for you? Rebuttal is 5 minutes.
Usually 3 minutes on rebuttals.
Right.
Okay, so first off, I want to disagree with the deletion of the original complaint against the Government Audit Committee where I complained about Supervisor Chu. At that time, Supervisor Breed was the chair of the committee. What's relevant is in that Government Audit Committee, that was hearing draft responses to a grand jury report. The grand jury is an arm of the Superior Court. The idea that Supervisor Chu said he's going to introduce amendments, and then in a packed room, there were a few copies distributed up front But this is to an arm of the court, and there was not time for anybody to fully read through everything. And in addition, there is a requirement there always be available for public inspection a copy of any document. There wasn't. Whatever copies were distributed of his amendments, people up front got. Those in the middle and the back didn't get anything. So we didn't really have detailed notice of what the response was going to be. And this is not just response within city government, it's outside to the court. That's why I think this was relevant to say you did it too quickly. That Supervisor Chu's no longer on doesn't mean this wasn't a problem. Don't take the accusation against the person as meaning the absence deletes the problem. And further, the idea is that because when the supervisors make a response, or the mayor, whoever is called upon in a grand jury report to give a response, that's a commitment. And so when suddenly there was this change in committee of this draft, and it was rushed through, suddenly after the committee hearing adjourned, there is no further public comment. It would take heroic work of sorts for advocates to try to clarify, back out, change whatever was amended in. There's further restrictions. The grand jury report, members have to just stick to what's in the report. So if the response by any agency seems to change from one draft to the next, the grand jury itself can't comment. They've got to sit on the sidelines. That's the problem here, where the public, who was interested, as I was because I was on previous grand juries, the public is suddenly left with a rush to make things go easily, well, smoothly for, in this case, the supervisors. That's why I felt it worth making the complaint.
Thank you. Members?
And again, that's against the complaint that under the request from Supervisor Wiener was deleted. Nobody asked me about deleting it, and I disagree with the deletion.
You're talking about deletion on our part.
I don't know who did it, but I know Supervisor Wiener in one of his responses said, my complaint against Supervisor Chu should no longer be considered. Well,
Okay.
you know,
But
I'm the complainant. And
But he's named in here.
yes, he is. But again, what was read to you was just about one committee, land use and economic development, not about government audit and oversight.
That's,
Through the chair, is that part of the original 14095?
Yeah.
Because that's what we're discussing today. So you're saying that was part of the complaint, the second piece, and that's no longer in there?
Well, I'm just saying Supervisor Wiener said don't consider it.
Well, that's his opinion.
Oh, okay.
And, well, at the same time, when your clerk read it, your clerk did not read anything relevant to government audit and oversight. But only,
It's in the agenda.
all right, I'm going by what
Okay.
was read there.
Sure. Yeah, it's in the agenda. It says, failing to provide adequate opportunity for public comments at the Land Use and Economic Development Committee meetings of September 15th and September 29th of 2014, and the Government Audit and Oversight Committee meeting of September 11th, 2014. Does that sound correct to you?
Okay.
Okay. Just make sure we're all on the same page. Okay, so I have a question, and I was not party to this. I wasn't on the task force at the time, so, and reading through some of the documents here, I just want to get some clarification as to when, during the meeting, were these amendments introduced?
The item had been called. There was discussion amongst the supervisors, and then there was an announcement that Supervisor Chu had some amendments.
So it was after the item had already been called to the floor, and process was happening.
And while after the supervisors had finished their questions or comments, then it was Supervisor Chu's got some amendments. Let's hear public comment. So public comment was called before the amendments were distributed.
Okay.
Later, they were distributed, but not everybody had a copy, and there was no public copy for me or anybody else to go up and inspect.
Okay. Thank you.
Through the chair. And in your view, Mr. Planthold, those amendments were substantive?
Yeah. I will also say here again, as I've said in other complaints, there was no discussion between either the chair, Supervisor Breed, or the person making the amendments, then Board President Chu. There was no discussion with the city attorney present. Do you think these are substantive? What is your opinion as to whether or not these are substantive? No such question was raised.
Because certainly in the letter that they gave us here of August 18th, they seem to imply that there was a checking in with the city attorney, or the city attorney, by not saying anything, is implying that it's not substantive. And
I read that too.
I think that's a bit of a stretch personally, but...
Well, first off, if there was a check-in, it may have been done before the meeting, because the amendments would have had some input, concurrence, oversight from the city attorney. But if that check-in was done, it was not done with the public's knowledge. And secondly, as you say, it also seems to be like, well, the city attorney didn't object, and so by silence, that means it's okay. I mean, standardly in other areas of law, silence is not assent.
Right. And through the chair, those amendments, so there was discussion, then it was announced that Supervisor Chu had some amendments. So
Right.
It sounds like the amendments were arising from that discussion, and they were not necessarily...
I don't see how, because the amendments were pre-printed and
I
brought
see.
in.
Okay.
It was not like the discussion took a long time. The discussion was relatively short for that grand jury report response. And then we heard, after the SOUP's discussion, that here's some amendments Supervisor Chu's proposing.
And here's a few copies, and then move on, basically.
8, 10, 12, but it was a packed hearing room.
Okay.
Yeah, I would
Thank
have
you.
liked to see DCA Givner's response that was supposed to have been part of the...
I don't believe that was submitted.
Okay.
I printed the attachment immediately after I print the document, and I believe that's what they attached.
Okay. All right.
And I'm not saying I disagree with the amendments. This is a process question about the public figuratively being kept in the dark about what can be key items in the decision process or in the deliberations process.
Mr. Planthold, what ensued after that? Did someone bring up or object to the process at the meeting, and what was their response?
No.
Okay. There was no discussion.
I was scrambling trying to find a copy because I didn't want to object in ignorance.
Right. Okay, thank you.
Mr. Plano, did you actually ask them for a copy, the clerk at that meeting?
I was in the back of the room. I said to people around me, do you have a copy? And I hollered out from the back, are there copies still available? There was no response. Now, my voice is not always, let's say, easily hidden.
Thank you. I share that quality.
Thank you.
Task Force members? So I know that there's a section of the ordinance with regards to how amendments are introduced at different times, either before, after an agenda or a meeting notice has been posted, after the meeting started, but before the item comes up, and then after the item comes up. And
Page 39 has some italicized points that talk about this, but is from the City Attorney's Good Government Guide. That's instructive, but not necessarily authoritative.
Yeah.
It doesn't quote the law. It doesn't quote any regulations or prior interpretations.
yeah, that doesn't speak to my, it doesn't speak to my question here. It's a different, talking about a different section of the law. Let me see if I can find it.
So through the chair,
Yes.
I guess there's two pieces. You're looking at the mechanics of how the amendments were introduced and the timing. And I guess the second question is whether there was substantive and determination of that. And that second piece, I know most bodies have quite a lot of latitude in determining substantiveness or not. Or am I making that too simple, or is that?
No, yeah, the two items here that I think that are before us are, one was procedural, were the amendments introduced properly at the time that they were allowed to be presented? And two, were the amendments being presented considered substantive to afford the public an opportunity to comment? Those are the two items that are before us, correct?
Well,
Mr.
I will concede the amendments were introduced during consideration of the item. So you can say they were introduced properly. The question is, did the public have knowledge of the amendments in order to have time to analyze and respond to those? That is in doubt. I question that. And then, so it may have been introduced properly, but that doesn't mean the public had knowledge.
Well, this is not a unique case.
I know.
mean, we've had other cases, even when I was on the task force prior, where amendments were introduced during committees that were considered that were substantive, that were well known to be substantive, and that only a limited amount of copies of them were provided to the public at that time. And that was when that was a clear violation at the time for those particular items. So I'm not in agreement with you that the amendments can just be introduced whenever they feel like it. If the amendments are substantive, then there has to be, and how amendments are introduced it's one thing if you're sitting on the body, you're having a discussion, and you bring forward an amendment. It's another thing when a non-member of that committee walks in and drops an amendment down. I mean, that's why I bring up that section of the law. I'm failing to find this particular section.
I didn't want to say automatically that it is acceptable. I didn't want to contest it. Rather, it is possible. And yet the fact the public didn't have knowledge in time to respond to the amendments because there wasn't a public copy, I say lay that to the chair of the committee, to the clerk of the committee, even to the deputy city attorney present. Nobody was monitoring the disposition of the few printed copies that were distributed.
Through the chair.
Vice Chair.
Mr. Plantel, did you ever get a copy of those amendments eventually?
Nope.
What I'm trying to get to is how long were the amendments? What was the, if there had been a copy for everybody in the room, the speed at which those amendments were then
It was
discussed
at least
and voted on?
three sides of paper.
Okay. So those that did receive copies, were they given a chance to properly absorb the material and then?
Nobody really commented. Nobody from the public who said, I like this amendment, or this amendment perplexes me, or I disagree.
And public comment for the amendments was not called?
It was during the whole discussion where public comment was allowed. But again, the fact nobody who even got a copy raised any question makes me say maybe there wasn't time to consider all of this.
So the members discussed the quick few copies of the amendments were, given to the people in the front, and then they went straight into public comment. Was that the order? Okay.
Actually, I'm sorry. Public comment was already in process when the printed copies were brought in.
The public comment was over at that point?
It was not over. It was in process.
In process, I see.
Just to clear up in my mind, because I'm reading the letter from Supervisor Wiener and Cohen. And so the complaint is regarding the meeting on the 29th or on the 15th? Or
The The first one I wanted to focus on was government audit and oversight. You're asking me to remember a lot of
Okay,
dates for
so
different meetings. The
what
Government
there's-
Audit and Oversight Committee.
Okay, what they're saying here is that amendments were made at the meeting on the 15th, and that item was continued to allow for further public comment. And
That's
on-
land use and economic development. That's not government audit and oversight.
Which was on September 11th. There was only one meeting.
Right.
What page is that on?
It's in the agenda.
Yeah, what page?
You can look at page 29 of the packet.
Okay, thank you.
It's the second page of the October 16th, 2014 lengthy memo. September 11th, 2014. Further, I guess I'll call your attention to, if you go to the back to page 85, you see at the bottom in italics the list of speakers on this item. Two of them were from the grand jury, and like I said, they can't really say anything. In fact, the amendments didn't come until after Rob Van Ravensway and John St. Croix, the then executive director, had already spoken. So here again, limited public knowledge contact. Some of this also bears on my second complaint.
Yeah, I know, but...
And I know you've got a
they're two
6 o'clock
separate.
special call, so...
Let's finish with this one
Yeah.
first. DC Acola, are you familiar with a section of either the ordinance or the Brown Act with regards to how amendments can be introduced? I seem to remember it was in one or the other, and I can't, I've looked at your memo. I don't see it in there.
Mr. Young, I'm going to be using this mic now.
Memos.
Oh.
Your memo starts on page 56.
Well, I didn't know who's going to do. Okay.
To go back and research that old case to find out.
I think what this really boils down to is whether or not the amendments rendered the agenda item description deficient.
Well, I mean, it still could be within the same context of the agenda item description. It just could be expansion of the detail that's within it. I mean, that's in the Park Merced issue. That was the contention in 2011, I think, or 2011. That the amendments that were brought forward didn't change the description, but it changed the nature a certain significant part of the original motion. It changed the nature of it. So it was considered substantive. The amendments were substantive. Nobody disputed that they were substantive at that time. They were. Mm-hmm. So I want to. I don't think that's where we're at right now with this.
Through the chair.
I disagree.
Okay.
To Mr. Clerk, do we actually have the amendments in here? Are they in our package?
I do not believe so.
I'd kind of like to see the amendments. I'd kind of also like to see the Givner memo. I think we're kind of incomplete without those two pieces. I mean, we're kind of discussing something that we don't have all the parts.
Member Josh Wolf.
So I've got a couple, I guess we could call them concerns. One, like, in essence, the way that this narrative from the supervisors is written is that basically, unless the city attorney interjects and says, actually, that amendment is substantive, there's nothing anyone can really do. At the point that, like, this meeting's now 2 years old. If this is the only process to identify that a substantive amendment was made and it takes this long to remedy it, we don't actually have a way to remedy the decision that was made. Like, the people that were involved in the decision are not in those same committees, and some people have actually moved on to new positions. And then the final concern I have, and maybe someone can speak to this, is were we expecting representatives from the respondent to be here? And if we were and they didn't show up, do we want to address that in some way?
Okay.
Through the chair, maybe I can answer Member Wolf's questions. I don't think we're expecting to be here based on their letter. They're saying that based on this letter, we respectfully request that the complaint is dismissed. So they think they've done their job, even though they haven't attached part of what that letter is. And I agree. This is 2 years in the past. There's other things that are on our agenda tonight that are more timely, that are more, I guess, immediate and can be affected by how quickly we rule on them. I think I'd like to see this continued. I'd like to get that Givner letter. I'd like to get the actual amendments. I kind of just see that. And we can always, just to play it out, we can always go, and if we do find a violation, we can document it and then decide whether we move on that or not. But I think right now we're incomplete based on what I see here.
Okay, we're taking these items case by case. So there's a set allotted time for every hearing. So I think we're still within another 5 or minutes or so on this particular item. I too would be interested to see the advice that DCA Givner gave to supervisors on this particular issue, considering that's their legal counsel who would also help determine whether this was a substantive item or not. As far as whether the respondents are here or not, it's not the first time that cases have been heard and orders of determination have been made without the respondents or even the complainants in attendance. Lots of times, from what I understand, items that have come from subcommittees that have made recommendations for orders were made without any of them present. So I don't think that that's an issue here. I'd like to also take a little time to try and find that section with regards to the time factor of introduction of items that are not appearing on the agenda or that would cause substantive change in the item that is already on the floor. DCA Kola.
The closest we're going to get to that, I think, is Brown Act Section 54954.3, subsection A. It starts at the bottom of page 65 in my original advice memo from 2014 in this issue. I think we've kind of been spinning our wheel here, but there's no clear definition. The Brown Act doesn't list what definition they want to adopt of the word substantive, but they'd have to reopen public comment if, after the close of public comment, the amendments that were made made the item substantially different from when public comment had been open. We asked them to come back with more information as to what their DCA advised them regarding this, and apparently they didn't come back with that. So I think from here, just determine whether or not you want to adopt your own definition of substantive and rule on this, or cut them some more slack and get a clear answer from them. But so we've already. What's the end game here? What are we going to do for a case that? This is 2 years old now. Maybe we should ask. Maybe we should ask the complainant what his ultimate end game is here.
Through the chair, just looking at past notes, we did have at the time, and then attorney, former member Rummold, look at this to see whether he, could find a violation, and based on 549, 543, he did not. Thus, we had those questions, definition of substantive, et cetera. And I have to agree with DCA Cole. They haven't really answered those questions. They wrote a letter saying they had, and here's the attachment. There's no attachment. Ultimately, those questions have not been answered. And here we are, 2 years plus going on. So,
members, anything else on this? All right, so I'm inclined to, sounds like we need a little more time on this. I think Mr. Planhold, let me ask you this question. With regards to not necessarily when or the procedure of introducing the amendments, but whether public comment was required because they were substantive, did you provide evidence at the time that the amendments were created a substantive difference?
When you say at the time, do you mean at that hearing?
No, at the task force.
Because first, I don't have any copy of those, but secondly, I keep saying I don't know that they were or were not substantive, because separate from that, there was no specific action, decision, question, discussion whether or not they were substantive. It's unknown. It's unclear whether or not they were substantive according to the normal working of processes. Nobody asked a question. Nobody made a suggestion. It just, boom, went through.
Okay, but didn't you see the amendments afterwards, after they were passed? I mean,
did.
They were part of the
I
record,
did see them afterwards.
And were they, to you, considered to be substantive
Again,
at that point? I mean, then it begs the question of the complaint.
They could have been, but there was no action taken to say they were or were not substantive. So even if I thought they were substantial and everybody else disagreed, my claim is there was no process for determining whether or not they were substantial. There's no process done.
Okay.
Maybe I'm in the minority about whether it's substantial. That doesn't rule out the fact that nobody raised this issue.
Is that what you want us to consider?
I think that's because even though it's 2 years past, you're not going to change the grand jury response. But this is going forward when there's future decisions, whether there's future revisions of the task force, to have better understanding of the process. Maybe a simple nod by the sponsor to the city attorney. Is this okay? Something as simple as broad as that. But right now, it leaves open this vague silence as being assent.
So it sounds more like how the rules of order in the Board of Supervisors on how they introduce amendments is that there needs to be some work done on that.
Maybe there, but also in the training, I think, that is given through the Good Government Guide. But I don't know what other means of instruction and of clarification there are in existence or can be used separate from amending rules of order or the Good Government Guide. I don't want to be limited to those two when there may be other information that is instructive to supervisors. There's aides, the committee clerks, and the assigned deputy city attorney.
All right, thank you. So I'm somewhat inclined to. I mean, I don't necessarily have enough information here. Even as far as we've gone with. I would like to know if the item was substantive because I know that this task force has taken positions before on such items in this way, but based upon the complainant's assertion, I'm more inclined to send a memo to the Board of Supervisors saying that we want clarity on how you introduce amendments and whether and how you would determine them to be substantive or not. And should they be like a big rubber stamp that says substantive that after it's been reviewed before they're introduced in that kind of way? that's kind of, because I want to be responsive to what the complainant's real complaint is here, and, rather going on a fishing expedition, which I don't want to do. So, I'm kind of inclined to find no violation because I don't, it's hard to determine that without the rest of the information. I hate to continue this to another time and take up more time for other items, but I would be open to having the task force send a memo to the Board of Supervisors requesting some clarification. And we have the letter from the clerk, which I think was very helpful. But I think it's important to hear from the board themselves, the ones that create and manage their own rules of order on how they do this,
Yeah,
and that it's of interest to us. Member Canada.
And it definitely seems from the letter that they wrote that silence does mean it's not substantive. Because the paragraph says that...
In the microphone, please.
Thank you. Let's see, where am I here? To determine whether a particular amendment is considered substantive and therefore necessitating additional public comment. When an amendment is made, the deputy city attorney present at the hearing determines whether it is substantive. If a determination is made that an amendment is substantive, he or she or a committee member on his or her behalf makes a statement to that effect, and the underlying item is continued to a future hearing to allow for additional public comment. That's it. It doesn't say if they say it's not substantive, it seems like they do nothing.
Okay.
So maybe in a letter to them, a suggestion would be that either way they should make an announcement so that the public waiting for comment knows that this is their time.
DC call.
Yeah, through the chair. If the complainant was making a contention that this was substantive and that they violated public meeting laws by not holding additional public comment, I'd say this is right in our wheelhouse. But he's not even saying that. He's just saying that they should do something, that they should have a protocol in place to rule on what's substantive and what isn't. I don't really think that's within our jurisdiction because there's nothing in the Brown Act that I could see that mandates that there's a protocol that has to be followed for that. I don't think there's any reason to continue this complaint. If the task force wants to write a letter recommending that the Board of Supervisors conducts their meetings and they have a protocol for what's substantive and what isn't, that's one thing. But I don't think there's any need to continue this matter. We just close it out.
Thank you. Any other members? Anything else? Mr. Planhole, do you want to say something?
Statements are being made about what I contend that I didn't make. So let me go back on this, that I said I think the amendments could be substantive, but I don't know. It is the silence. And therefore, that's still to be determined. I didn't say they're not substantive. Separate from that, what member... I'm sorry, I can't read. Canada read, indicating there is a Board of Supervisors protocol or process regarding this. Your counsel said it's silent in the Brown Act, but the supervisor's own statements, whether it's in their rules of order or some other guide, indicates there is a process.
Yeah, but that's not part of Sunshine. That's part of their own process. So if the Brown
Act... But it allows complaints such as mine to come forward.
Sorry?
It allows complaints such as mine and such as the subsequent one also to come forward because of this lack of precision, because of the lack of specificity, because of the lack of statement.
Right, but if the procedures were properly followed and there's nothing that regulates their procedures, that their procedures are their own, and they were properly followed, doesn't become a Sunshine issue unless you can show that the amendments were substantive. If the amendments were substantive, then we have something to talk about. But that doesn't seem to be your assertion.
Because I don't have them, the copy. And so you're putting the burden on me to overturn the entire process that the Board of Supervisors follows with concurrence and advice from the city attorney.
But we can only.
If I've got to show it's substantive.
But if we're not provided with the evidence to show that there was a violation, then we can't. We're not going to go on a fishing expedition for it.
Okay.
That's what I'm saying. It's like we're interested in the topic. We think we don't know if it was substantive or not, and whether public comment should or should not have been allowed at that time. So we're left in the dark. We can only go with what we have. I mean, I don't know if the task force wants to take the time to do that. I'm not feeling it among members here. So if they're, I would just say that, for this kind of complaint, there should have been a set of the actual amendments presented, because, the complaint speaks to that public comment wasn't provided, because you don't know whether it was substantive or not, but the process doesn't describe well enough as to whether something is substantive or not. It would be up to your complaint that they were wrong, I am right, and it's that kind of thing. So that's why we're kind of struggling here.
Mr. Chair, maybe we should get some public comment and then.
Yeah, I've got it. Thank you. Member Canara.
The only thing I was going to add to that, it seems that from the letter from the Board of Supervisors, even if somebody does think the amendments are substantive, that it's up to the city attorney to make that decision. So if we take something like that up, do we then try to change that process?
Only if we're provided that there's actual evidence that a violation has occurred, okay? Or if there's a dispute, that's our job to adjudicate that, right? So that's kind of the point here. Okay, so let's get some public comment, and then we're going to see if there's a motion.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. First, I'd like to, all due respect to Deputy City Attorney Cola, regardless of when it happened, is not an issue. If it happened, and you sometimes need to establish the fact that something happened, so that if it comes up again in the future, you can say, this is something that is seemingly coming up on occasion. As far as the deputy city attorneys, my experience has been in all the boards and commissions that they act in a totally passive capacity. Unless they're specifically asked a question, they keep silent. And silence does not give consent. It does not say that the changes were not substantive. It doesn't answer it in any way, one way or the other. The second thing is, this is, as Mr. Member Wolf mentioned earlier, the Park Merced case went on this because after the committee meetings had been held, at the full board meeting where final passage was being voted on, Member President Chu came in with 14 pages of amendments that nobody had seen, and again, in the same situation, had only copies for about a quarter of the people in the room. And if I understand Mr. Plantle correctly, in this particular case, public comment was proceeding. Well, if I had already made public comment and did manage to get a copy of this and saw something that I considered substantive, what am I supposed to do? They're not going to let me talk a second time. So basically, it seems like this little modus operandi where we're going to put some things out there, and in particular, I'm going to slip back some things that we took out because a lot of people objected to it, and then I'm going to put it in at the last minute without anybody having a chance to look at it until it's already a done deal. So I think really this is something that is worth the effort of going back and looking at the changes and seeing whether or not they could be considered substantive. And the fact that it happened 2 years ago is, in my mind, irrelevant. If it happened, it happened. Park Merced happened. The task force found a violation. It is now, a precedent for the task force. And therefore, going back and looking at a case that happens to be a couple years old is not necessarily of no value, because it can be of value to show, the supervisors seem to be playing fast and loose with the rules relating to what the members of the public are allowed to comment on. And lastly, I'd like to say one of the things that I've had the most problem with is getting access to public records. When the body that you're talking about or the agency doesn't want you to comment on something, one of their first things is to withhold the public records you need to speak. And basically what they do is they violate your right to free speech by denying you the sources you need to effectively make the speech.
No, not really. Peter Warfield, I'm not a party to this and am not involved directly with this, but I do want to support what the previous speaker, Ray Hartz, has said. I think it's very inappropriate of your attorney to, first of all, complain about how long this has taken, as though it's all the complainant's fault, and second of all, to ask the complainant what his justification is, what his so-called end game is. I don't think it's up to the complainant to justify why he has brought a complaint. I think it's up to the body to determine whether the complaint is supported by the complainant and the law. I appreciate your body's willingness to work on this, because I do think that many times complaints bring issues that are significant and are important both for the complainant and for everybody else, and for your own understanding for the future of what is appropriate and what is not appropriate. So the Board of Supervisors does not get to write sunshine ordinance. They could have a procedure that says we don't take public comment ever. That doesn't override the sunshine ordinance. If they decide that they are going to have certain procedures for certain circumstances of substantial changes, and they're going to have procedures for deciding it, that's very nice, but it's up to you to decide. For example, was there a change that made a difference in what the agenda item said? And if they have explanatory documents, now all of a sudden they're throwing something in, presumably, that hasn't been seen by the public. That changes what the discussion is about. And as Ray Hartz just said, we see that all the time. Documents dated the day of the meeting that are not distributed with the agenda, and all of a sudden the public has to scramble to even see what they're planning to talk about. And I think those are serious issues with respect to sunshine. The Board of Supervisors and the Library Commission and any of these bodies don't get to rewrite the law according to their desire to operate a certain way. They can make rules, but those rules have to be within the law as you determine it when there's a complaint. So I would be very concerned about the integrity of what the public was told in advance, because all of this is required by law to be presented to the public in plenty of time for them to look over all the material and make a good ability to make comment. Thank you.
Members? Is there a motion? Member Josh Wolf.
I don't have a motion. I have a comment based on like the public comment that we were hearing, and I want to explain that when I was speaking of the 2 years, I wasn't saying that like we shouldn't bother with it because it's 2 years. What I was trying to speak to is that basically, and this is sort of coming off of what Ray Hartz was saying, is that unless we have some more a greater efficacy in dealing with complaints of amendments being substantive, we don't have a sensible protocol to really actually deal with this. Like, as Hartz mentioned, he wouldn't be able to argue in the meeting itself that he felt it was substantive. So his first course of action would be to file a complaint with us, and then at the next meeting he could argue that it was substantive. But none of this actually sort of addresses the problem. In digging through the complaint, I don't see anything to really cement that case that there were substantive amendments. However, I think that we do need to remedy this situation because there is this ambiguity that's problematic, and our way of addressing it right now doesn't really serve an effective solution, as evident by the 2 years it's taken to address this one.
Thank you. Anybody else? Okay, so, you know, I hear what some of the public commenters are saying. The difference between this case and some of the other cases is the other cases presented actual evidence that refuted the substantiality threshold, where they presented minutes or actual documents or actual language or something that said, you know, what was determined at the committee level by the members of that committee as not being substantive, or they didn't take up the issue at all of it being substantive, or they were advised that it wasn't substantive, was in fact by here I'm presenting as the complainant the actual items, and here is exactly where it says that it's that I contend that it's substantive. Then this body, the Sunshine Ordinance Task Force, has the ability to come up with a determination. But lacking that information, just for the sake of stating that there was, you know, a lack of public comment because there were amendments that were presented, and that there wasn't an opportunity there wasn't a presentation or a determination at the time of whether it was substantive or not, is not really in our wheelhouse. That's not for us to determine. Now, we can say, okay, maybe there needs to be some strengthening in the Sunshine Ordinance to force what it could bring some conditions as to what is substantive, what is not. I mean, the only thing it says in the ordinance under 6715 is unless the item has been substantially changed since the committee heard the item as determined by the board. So it's not even as determined by the ordinance, it's determined by the board. It's a self-determination. So that's where, you know, I have to agree with DCA Cola, you know, specifically on the merits that it's really not it's not under the ordinance for us to make that determination unless the complainant brings the complaint forward that there is evidence to show. Okay, I mean, the complaint has to have some substance to it. Okay, and it's up to the respondent to say, I didn't or we didn't violate because the law says this, that, the other thing. In this case, if it's substantial or not, it's really up to the board, that governing body, to determine it, not us. Okay, unless it's been presented, the actual has been presented otherwise. So that's where I'm standing on this. Anything else? Okay. Is there a motion? Seeing no motion, item is closed.
Item number 5, file number 14095. There being no motion, the matter is hereby concluded.
Okay.
We'd like to move to item number 7, public comment.
So I'm sorry, what?
It's 5 o'clock, public comment.
Oh, 5 o'clock, yes.
Item number 7, public comment. Members of the public may address the Sunshine Ordinance Task Force on the matters that are within the task force jurisdiction, but not on today's agenda.
Members of the task force, some of you may not be familiar with what I'm going to talk about, but I'll fill you in as best I can in the time I have. I'd like to read to you something very briefly from the Good Government Guide about the roles of commissioners. When acting as in a quasi-judicial capacity, members of boards and commissions function like judges. They must take care to ensure that the parties appearing before them receive due process. I had 4 cases that I filed against the library. Each of those cases was filed separately. It was against an individual for a particular violation of a section of the Sunshine Ordinance. Each was different than the other. They were part of a continuous series of events, but they were filed separately, and on the agenda the day they were heard, they were placed as 4 separate agenda items. No announcement was made at the beginning of the meeting that any agenda changes were to be made, and immediately before, I had 5 cases on the agenda that night, which is kind of a long haul anyway, but immediately before the second case was heard, the chair decided, without any discussion, to hold all 4 of the hearings at one time. Now, I had prepared 4 separate hearings with 4 presentations, and I've talked to this body about that before. And being told at the last minute that you now have to take 4 separate presentations and merge them into one is, I believe, a violation of my right to due process, especially when we're talking about a body like Sunshine, where sticking to the agenda and following the agenda is something that you enforce on other city bodies. Now, those cases were all decided as no violation, but I think a lot of it had to do with the fact that the entire procedure was jury-rigged. It was, oh, we'll give you 20 minutes here, and we'll give them 10 minutes, and we'll give you this and this, that. And it was done in a way that was totally unfair. Now, I asked for a continuance. And I think most of you, having watched television or maybe even been in court, know that no judge would say to an attorney, oh, you have 4 separate cases, I'm going to hear them all at once today, and no, you can't have a continuance to rearrange your argument. We're going to make you do all 4 of them consecutively and at the concurrently. So basically, I'm asking again for leave to either have these hearings reheard, these cases reheard, or to file them again. It was unreasonable, and the justification that, well, we've done this before is not enough. The simple fact that you've done something before may have been just as unfair to the other people you did it with as it was to myself. I want these cases reopened or leave to represent without having to go through the duplicative crap that poor Mr. Warfield had to deal with.
Any other public comment?
Peter Warfield, Executive Director of Library Users Association. I certainly want to support Ray Hartz in his just made comment. I think that combining cases is not only chaotic, I think it's inappropriate when you have no procedure that you have written down for how to do that. And you do this by the seat of your pants every time, and it leads to more or less confusion and chaos. It's also unfair. It complexifies, if I may create a word. It makes much more complicated what would otherwise be a single thread followed by another thread followed by another thread. And we see that when responses to complaints come in grouped together. I've certainly experienced that. And we see that when the attorney, your attorney, gives group answers. The duplicative, supposedly, complaints that I had were grouped together so that the 2 new ones were compared with 2 old ones, when in fact, what was being said was duplicative about what? It wasn't clear. It would have been a lot simpler to say this one is supposedly duplicative of this other one, and then a person wouldn't have to go to 2 and 2 each time and try and figure it out. On another matter, I've said that educating the folks here. By the way, I notice people leaving on occasion, and I would ask you to give mercy breaks to folks regularly. Every hour and a half or 2 would be nice, because the public, if it wants to stay for the whole thing, can't just walk out without missing something. I've said that the folks here, as well as the public, I think would be well served to have education about what is the meaning, basic laws, and I think that needs to be done publicly here in public. So, for example, 67.21, every person having custody of a public record. What's a custodian of a public record? I think that the city attorney and others have tried to completely confuse the issue by talking about somebody who's appointed basically as a PR person versus somebody that any person may approach for information. 67.21 says every person having custody of any public record or public information and so on shall at normal times and during normal and reasonable hours and so on permit the public record to be inspected and examined and shall furnish one copy thereof upon payment and so on and so forth. A custodian of a public record in section B shall as soon as possible and within 10 days and so on. What's 10 days? Somewhere it got to 14 days. Why? Where? According to whose definition? I see 10 days as 10 days, and I see every person as every person. And there's more to be said about that, but unfortunately the city attorney's good government guide differs with the law in this and in other examples. Thank you.
Any additional public comment? Okay, public comment is closed. Oh, one more. Ms. Trudeau?
Sure. I just have an issue with people who bring forth complaints and then withdraw them at the last minute. I think it creates an undue burden on your task force. It's a waste of paperwork, waste of time. And, we have an example tonight of somebody who withdrew at the last minute, who has a history of doing that. And I think you should consider that somehow, some way, because it inconveniences everyone.
Any additional public comment? Seeing none? Okay. Let's move on to the next item, please.
Item number 6, file number 16034, complaint filed by Bob Plantold against Supervisor Katie Tang and Supervisor Norman Yee, Board of Supervisors for allegedly violating Administrative Code, Section 67.15, and California Government Code, Section 54954.3, by failing to provide adequate opportunity for public comment at the March 23, 2016 Budget and Finance Subcommittee meeting.
Okay. This is also a continuation of previous item. Is there you have anything to add, Mr. Planthold?
Well, because there's new...
Give me one moment.
Start again for the time. Because there's new people, let me start up. There was a hearing about child care family leave law that Supervisor Wiener drafted and was before this body. Public comment was taken. At the end of public comment, then Supervisor Katie Tang, the chair of the committee, said she was going to propose an amendment that would narrow the types of companies subject to this law and the length of time that somebody would have to work in order to be eligible for this paid family leave. So it made it a larger number of employees a company needed to have in order to be subject to this law, and it made more time. Nobody had knowledge of that. In the first complaint I talked of earlier, at least Supervisor Chu said he was going to make amendments, and he brought in paper copies. In this time, public comment was totally closed. Then Supervisor Katie Tang said, oh, by the way, I'm going to make these amendments. My complaint against Norman Yee was because he seconded it. If he had not seconded it, the motion would have died or could have died. It would not have proceeded. But she's the one who closed public comment, then said, I'm going to change this. And the effect was having coverage of fewer companies and fewer employees. And to me, that is substantive. Again, there was no discussion. There was no question through a microphone. Nobody went up to city attorney. There was zero response on this. Suddenly, boom, public comments closed, deleting amendment made, seconded by Supervisor Yee, and it went through. That, to me, was wrong.
Okay. Thank you. And is the respondent here? No. Okay. All right. So that makes things a little more clear on this item. Members? Anybody?
If I may, there's still time left. I want to point out there's the memo that's signed by Supervisor Yee and by Supervisor Tang, in which they said towards the bottom of the first page, it's a memo of April 11th, there are good policy reasons not to circulate proposed amendments until after hearing the public comment and ideas on the item. Well, I'm not aware that that debate's been had, but in fact, these were not amendments of text. These amendments were deletions. And yet they're claiming good reason not to tell people in advance we're going to make changes.
Thank you. Members?
Yeah, but I've been arguing that with the first one, and they didn't bite. They say it's not their role.
Any questions, any comments?
That's
Any motions on this item? It is definitely different than the previous item. Okay, so is there a motion?
I mean, reading through the response, I mean, they have a different interpretation of how the law works here, and I mean, does anyone have an opinion they'd like to share about who is right or wrong before we vote or make a motion?
I think the presentation by the complainant on this item was very different. I mean, he's presented evidence in his testimony that the item was substantively changed, that there was actually an effect on some of the detail of the item, and that it was after public comment had already been closed, that the amendments were then introduced, and then there was no further public comment allowed or called for at the time. So it was moved, it was seconded. Did the item pass? Yes. The item passed. So that, clearly would be unless there was a response from the respondent, which the only thing I'm looking at is on page 108. Is this January 2nd? No, this is March 23rd.
107, right?
Oh, here.
And we're essentially saying that it was substantive enough to count, even if they don't think so.
Well, they
if
say.
we were to vote.
I'm sorry. They say here the complainant incorrectly asserts that public officials are legally required to announce potential amendments before public comment occurs. That is incorrect under the Brown Act and the Sunshine Ordinance with no citation. Committees must allow the public to comment on legislation, quote, before or during the legislative body's consideration of the item. So if you brought forward an amendment and somebody moved it and seconded it, that is exactly what this is describing, an item that is before the body for consideration. That's my only. That's what I'm stating as being a significant difference than the previous item that we heard.
So it's not a question of substantive, but it's a question of when it was proposed.
Yeah, was the process, was the Sunshine process, or actually the Brown Act process, was the Brown Act actually processed properly? Whether it was an amendment or not, if an item was brought to the body, somebody moved it, seconded it, there's got to be public comment on it. Okay? If there was an amendment that was brought to the floor, whether or not copies of papers or whatever, if it was substantive and the complaint is saying that it is, then a public comment under both the Brown Act and the ordinance requires public comment. I don't see anything in the respondent's memo that says otherwise.
I want to be clear. I felt it was substantive because it reduced the numbers of companies and reduced the number of employees eligible for these paid family leave benefits. I maintain it was substantive.
Yeah, no, I did. That's what I was saying.
Your new members said differently, and I wondered.
Oh, okay.
I was just clarifying what the issue was that we were discussing at the moment, which is the question of procedure rather than the decision of whether the actual content was substantive or not. Which I understand you might be asserting, but that's
right.
Putting that aside, regardless. Thank you.
Yeah, again, just to reiterate, under Section 6715, it states that, however, in the case of a meeting of the Board of Supervisors, the agenda need not provide an opportunity for members of the public to address the board on any item that's already been considered by a committee, composed exclusively of members of the board, at a public meeting wherein all interested members of the public were afforded opportunity to address the committee on the item before or during the committee's consideration of the item, unless the item had been substantially changed since the committee heard the item as determined by the board. Okay, so really kind of under this particular section, that is specific to items that have come before the board from the committee that may have been substantially changed. That's kind of, even still, during a committee, you would think that if there was and the task force has taken this up on many occasions before, and there may be a different section that speaks to that. But that's the thing. Was this, so when you went to ask for, let me just clarify, this was all happening in a committee, or did this happen before the Board of Supervisors?
After the committee ended their deliberations, I emailed to the sponsor, Supervisor Wiener, this concern and asked if he felt there was a problem. His response was, I'll let the board decide.
Okay. Okay. Members? I'm not going to let this go too much longer. If there's no action by anybody. Okay. So seeing no motion on the floor, the item is closed.
Comment?
Oh, public comment. I'm sorry. Public comment. My bad. Sorry.
Peter Warfield, Executive Director of Library Users Association. We're not associated with this or involved in this case, but I do think that there are some very serious questions about open government raised here. Excuse me. I do take the point of the chair, which he made on the previous item, that public testimony 67.15a concludes with what appears to be an out for specifically the Board of Supervisors. And it talks about the relevant phrase is, unless the item has been substantially changed since the committee heard the item as determined by the board. What I would say is, where and in what form does the determination take place? I think the complainant here made a good point previously on the previous item, and that is there any sense in which a determination has been made that this has even been considered by anybody on the body or the body itself when changes come in? And I think, just as you say, public comment, that indicates that you're considering public comment. If you don't say public comment and move on to the next item, then you haven't considered public comment. Likewise, I think you make some indication that the change that Mr. Planthole described is, at least in somebody's opinion, not a substantial change. And I do think that the public has a right to expect that some nod toward this procedure of making a determination should take place. So my thought on this is, yes, the board determines, unfortunately, and you may argue with it, but the question that I have on this item is, well, I certainly think you can argue about whether the determination was fair or accurate, but I think you can also argue, was there a determination made? And if there is no evidence of a determination being made, then I think there's a potential problem. Thank you.
Any other public comment?
Members of the task force, Ray Harris, Director, San Francisco Open Government. I think the crux of this really comes down to equity. If you want members of the public to attend and participate in public meetings, you have to be fair to them. Now, if I was at that meeting and I got up and I made a public comment saying I supported this legislation, I think it's really great, yada, 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 only to sit down and then find out that after public comment is closed, you changed it. And the reason I was supporting it was because it would cover me and my family. And the change you just made has just knocked me out of coverage. Obviously, that's not equitable. And it would certainly be something I would want to comment on, and it is a substantive change. And so I think it's kind of, it's odd that this would be allowed in the purest sense of the sunshine, in the sense that if you want people to participate, the game has to be set up in a way that they feel their participation is meaningful. One of the very first cases I brought to the task force was a police commission meeting where at the beginning of the meeting, to a packed room, the person running the meeting said, "How many of you are here for item number 5?" 3/4 of the people in the room raised their hand, and at that point, he said, "Oh, well, that's so this meeting won't run too long. We're going to continue this and have the meeting at another time." And basically saying to all these people who had arranged for family care and to take off time from other activities were denied the right to speak and told, "Oh, at some predetermined time in the future, you will be allowed to talk about this, but we're not going to tell you when that is." And all I could hear was the dozens of voices going out talking about what a bunch of a-holes they were, and they didn't really want the public to participate, and going before them was kind of a meaningless exercise, because when they don't want you to talk, they'll find some maneuver to prevent you from doing so.
Any other public comment? Okay, seeing none, public comment is closed. I'll just add this item, and this is not something, and I would agree with public member Hart's on a lot of that in spirit, but in a perfect world, I would wish that the task force could do such things, but we're governed by laws, and laws can be changed. But for this particular item, this is something that we're overruled by. And specifically on this particular kind of case. In the Brown Act and the Government Code under Section 54.9, 54.3A, it speaks to regular meetings that members of the public shall have direct access to the body for public comment or what have you within the subject matter, and that no action shall be taken on any item not appearing on the agenda unless the action is otherwise authorized by the previous subdivision. Okay, so the question then becomes, is an amendment then an item that did not appear on the agenda, or is it still within the jurisdiction of the item that is already on the floor? Further, it states, however, the agenda need not provide an opportunity. This is almost word for word what's in the Sunshine Ordinance. need not provide an opportunity for members of the public to address the legislative body, which for the Sunshine Ordinance would have been the Board of Supervisors, on any item that has already been considered by a committee composed exclusively of members of the legislative body, or quote-unquote the board, at a public meeting where all interested members of the public were afforded opportunity to address the committee on the item before or during the committee's consideration of the item, unless the item had been substantially changed since the committee heard the item as determined by the legislative body. So this is state law. So if we really think that we want to change the way substantive items are considered, then there has to be some amendments to state law to make it a little more specific on how that is. Otherwise, it is left up to for sake of a better word, the whims, essentially, of a local body to determine what its rules might be, whether to just let it ride or whether to be very specific on how substantive items will be determined or not determined. And so I think we're kind of overruled on that item. I would like the idea of creating, be able to take action on equity, but I don't think we can do that. So I'll leave it at that. Anything else for the good of the cause? Okay, seeing none, this item is closed.
There being no motion to find violation, this matter is concluded. Next on the agenda, item number 8, file number 15072, hearing on the status of the order of termination, complaint filed by Ray Hartz against Supervisor Eric Marr, Board of Supervisors, for violating Administrative Code, Section 67.25A, for failure to respond to immediate disclosure requests in a timely and or complete manner. On July 26, 2016, the EOTC heard and referred the matter to the task force to find, with a recommendation to find additional violations of Administrative Code Section 67.21E and 67.34 by failing to comply or not fully complying with requests for public records, and for willfully failing to discharge the duties imposed by the Sunshine Ordinance, the Brown Act, and the Public Records Act. The committee requested that the respondent provide a written response to the immediate disclosure request, provide a written policy for responding to public records requests, and provide a record log of Sunshine Public Records requests received in the last 12 months. I believe that they have complied with the request of the committee, and those documents are in your packet today.
Great. Does any member of the EOTC like to carry this item?
What was the question?
Sorry?
Could you repeat that?
Would any member of the EOTC like to carry this item? Since this was heard in EOTC.
Sure, I'd like to provide a summary.
Sure. Vice Chair Highland.
Certainly. So just to give the other members a little bit of history here, I think we had an order of determination back in June of 2015. June 3rd, 2015, where we found a 6725 violation, failure to respond to an IDR. And I hate to say it, but there's been a bit of a history of non-compliance, non-attendance, just general disregard from Eric Marr's office to this particular case. So we've bounced it around in EOTC, and we've brought it back to the full task force with some recommendations that you can see in your agenda here. Some further recommendations.
Any questions or comments on this item? Is there a motion? So the committee brought some recommendations.
I move that we accept the suggestions of the committee.
I'll second that motion.
And moved by Member Kanata, second by Member Moss. Public comment.
I believe the respondent is here.
Well, is the respondent here? Okay. Well, I'm not going to re-adjudicate the case.
I'm not going to re-adjudicate. I want to support the motion.
Give him a chance.
Okay, go ahead.
It's already. Okay. Ray Hart's Director, San Francisco Open Government. And I would like, because most of you haven't been exposed to this entire case, I'd like you to look at this timeline. The original IDR was filed on March 19th, 2015. When it was an immediate disclosure request, and the page numbers there are the pages in your packet for what I'm referring to. And on page 142, you will see, 41 and 42, you'll see the immediate disclosure request. It is clearly marked immediate disclosure request. The actual request, this request is specifically for any and all documents, is in very large, bold letters. And at the end, right before the close, and another immediate disclosure request, it says, as this is an IDR, I would expect a response from each of you no later than close of business tomorrow, March 20, 2015. When I had not received any response and no request for a continuance, I filed a complaint on the 24th. The Sunshine Task Force held a hearing on May 3rd of 15 and found a violation, issued the order of determination on June 3rd, 15. Now, I would like to say that their defense was, well, we get a lot of emails and it was lost in the shuffle. Well, that may be good for the original, but what about when you got the complaint? They got the complaint and didn't respond to the complaint. I checked that with Mr. Young this morning, and there's no record they ever responded to the complaint at all. When the hearing came up, they came up with, I don't know what happened. It got lost in the shuffle. The order of determination came up, was issued on June 3rd. So they had all these opportunities to answer the IDR, and they failed to do so. Now we're talking May 9th of 16, we're having an EOT hearing, and they didn't even bother to send anybody or tell anybody they weren't going to show up. On the 31st, the memo went to Eric Marr's office from EOT saying we found these violations and we're recommending further violations, and he still didn't respond. When I finally got a response to my initial IDR was July 26th of 16, a year and 4 months after the original IDR. Now, if that isn't egregious, not only to myself, but the efforts of this task force, I don't know what is. Now, the real chutzpah is his response, if you look at it, and it's on page 157 of your packet, is basically, we don't have anything. So I'm a member of the Board of Supervisors. Somebody files a complaint. I claim this through this whole process that I don't know what's going on. I didn't hear about it, whatever. I don't respond to the IDR. I don't respond to the task force. And the bottom line is, I thought I had 5 minutes. What?
Well, we're not re-adjudicating the case.
Okay, well, I just...
Not generally under the regular procedure.
What is the regular procedure when you're making a recommendation on a complaint where I'm the party?
Well, because this was heard through the complaint committee, and wasn't the opportunity made there?
Yes, but the members here who are going to decide on this have not heard all of this. Many of them weren't even on the task force when this originally came before the task force.
I am not kind of privy to how the previous iteration of the board handled its task force handled how they brought these items forward in this kind of way. So can somebody enlighten me on that? Did you guys go through a regular 5-minute for the complainant and respondent?
I think given that we've got additional recommendations, I think that would be appropriate.
I just want to when we talk about equity, and it's equitable, we want to make sure that it's standard. So when an item comes from a complaint committee, in the past, it's just been to accept the items, and you kind of moved it along. Okay? What has been the case when the respondent or the complainant or the respondent wanted to, how did you manage that? Go ahead, DC Acola.
Since we've adopted the farming out to complaint committees, in my experience, it had been 3 minutes rather than the 5, since it had previously been adjudicated in a subcommittee. Also, I'd recommend sticking with that right now, because in the previous matters we had given them 3 minutes, and now we would be deviating and giving someone more.
Well, again, I'm not going to create new rules or run this by the seat of my pants. Or our seat of our pants. I'd like to know how it was done for the previous 2, 3, 4 years that this new complaint process has been in place.
The new complaint process has only been in place for approximately a year to a year and a half.
Okay.
And it has been practiced to provide 3 minutes for respondents and complainants to provide additional comments to either support or...
Okay, in this process.
Yes.
So, additional minute.
The deputy
give
city
you
attorney. The deputy city attorney is on the side of the city attorney who hates sunshine and will do everything in his possible.
Mr. Hartz, wait a minute. Just finish your comments, okay? It's not so much. I'm not so much taking into what he's stating, but I'm listening to what the administrator is saying, because he's the one that's been here, that's been following and running.
Yes, but cutting back my time based on something that I am not aware of, a procedure that you're now telling me, oh, well, we're doing this differently now than the years you've been coming to the task force.
I haven't been here for in the year that.
Well, I have, and I have never seen 3 minutes in any case.
For when so for the members that have been here prior, okay, because we got to get some agreement here, okay. What has been the procedure? Okay, when a complaint comes from a committee and it comes to the task force, what has been the procedure?
Yeah, when I was chair of complaint committee, it's like Victor. It's like Mr. Victor says. It's been 3 minutes. If somebody, when I was vice chair and filling in as chair, if somebody was on a roll and they really needed an extra minute or two, I would make the decision maybe to give it to them or not, but it was always 3 minutes.
Okay, so when a recommendation comes from a complaint committee,
and there's something to say about it. It's usually 3 minutes.
3 minutes.
Yeah.
Yes, Member Josh Wolf.
I just want to know if the recommendation is no recommendation from the complaint committee, are we doing that as a de novo hearing with 5 minutes, or are we sticking to the 3?
Well, that's what I'm asking.
Well, we have a recommendation in this case.
It's not de novo, sorry.
But when we have no recommendation, when the complaint committee does not issue a recommendation,
It's 5.
Are we going to 5 or 3? That's what I'm trying to figure out right now, because it does factor into what's happening right now.
Perhaps I can clarify, Chair.
My concern about this is, where does it say all this in the complaint process? Does it say this in the complaint process?
It doesn't say it anywhere.
That's what I'm trying to determine here, is because I don't want to have this conversation and stop our meeting and every time this comes up. There has to be some standard for this.
Through the chair, I think this is one of the things that we were considering in our procedures. I think it's something that the Rules Committee should definitely look at, and establish something. In practice, I think if there was a recommendation, we give 3 minutes. Sometimes the committee would find no violation. That was their recommendation, in which case, still be 3 minutes. I'm not sure we ever or have yet proposed a de novo hearing, which may require more. I don't remember that.
I did.
Yeah.
There were 2 instances, I don't remember them off the top of my head, where, and a member Hinsey was with me, where we sat there, and as we didn't have the city attorney with us, we said, this is beyond our, the complexity is too much for us, beyond our comprehension, let's move it back up. And then it started as a whole.
In those cases, when we put up the recommendation, we put it up as we wanted to go back as a de novo hearing. So it was indicated that we wanted the full time and everything.
Okay.
Correction, I do remember that one case, yeah, or two
Okay.
cases. So that, just to summarize, that has been our practice. I think it needs to be memorialized going forward. So that is, yeah.
All right. Well, this is a good example of what needs to be done here.
So I think what's appropriate in this case is maybe give them both 3 minutes and then discuss what the recommendations were, accept or don't accept.
Okay, great. Okay, so I want you to finish your thought, Mr. Hartz, and we're going to hear from the respondent, and then we're going to have a discussion.
This is a section from the Brown Act, request for records and agency response, and the particular lines I'd like you to pay attention to are the bottom two. The Public Records Act does not permit an agency to delay or obstruct the inspection or copying of public records. I think a year and 4 months is a definite delay. And finally, when a written request is denied, it must be denied in writing, and I did not get that denial for a year and 4 months. And lastly, 6734, willful failure shall be official misconduct. It basically says the failure to discharge any duties imposed by the Sunshine Ordinance, the Brown Act, or the Public Records Act shall be deemed official misconduct, and complaints shall be handled by the Ethics Commission. And all I wanted to say is I believe this should be found a violation and referred to the Ethics Commission for enforcement.
Is the respondent present? Please state your name for the record.
Victor Lim, Legislative Aide, Supervisor Eric Marr's office.
Okay.
Angelina Yu, also Legislative Aide to Supervisor Marr.
Okay.
At the last task force meeting, we had submitted the response to Mr. Hartz with the written response for his original IDR. As discussed, we had also shared the policies and procedures that our office now uses to try to avoid missing IDR responses. And per request, we had also followed up with a current listing of the IDRs received for the past year, as well as the topic it relates to and the response or action that our office has taken. So I believe we have provided the appropriate and requested documents.
Is that it?
Yeah, is there anything further that we could do to help address this outstanding case?
Do you need any explanation?
We will, when we start our discussions, we may ask you to come back.
Okay.
Thank you.
Thank you.
This is just your time to make a presentation.
Thank you.
Okay, members?
I had a question for Mr. Lim.
Yeah, don't go that far away. Come on up.
So based on the package that, the log that you gave us, I still see there's some gaps there where there's some requests for information, but there's nothing logged in the response. So based on that, that's a pretty spotty track record. Would you agree?
We've tried to improve moving forward. Unfortunately, yes, there are some instances last year that we did not respond. But moving forward, and if you look at the rest of it, we were trying to do our best to respond.
And is it correct that you were the first person that fielded Mr. Hartz's IDR back in March of 2015?
It depends on what time the email comes in, because at that time there was a different colleague. Emails are screened by me and by another colleague depending on what time the email comes in.
Okay. Are you the custodian of records for Supervisor Marr?
Would you like to define that?
Or let me say this, like, who's in charge of handling information requests, records requests, IDRs?
It depends on the subject matter.
Okay.
We do not have a point person.
All right. Thank you.
Thank you.
Anybody? Mr. Lim? So this particular issue was before I arrived here, but reviewing the records and hearing about a lot of it since we're coming here, I'm just wondering, was there seemed to be some particular times that you were requested to appear at either this body or committees, and you failed to show. Was there some reason for that?
We had some scheduling conflicts that was unfortunate with the times that were indicated.
Okay. For every single time?
Which?
I mean, I think there were about 3 occasions. Is that right, Vice Chair Hyland?
Yeah, there's one occasion where you're actually in the building, and our clerk contacted you, and you just said, "Sorry, I can't make it." That one I remember distinctly.
Yes, we had a conflict indeed.
Yeah, because, I don't know if you're reading you've read the recommendation from the committee. I mean, the recommendation is to find a violation of 6721E, which is the section around just producing the failing to respond and the documents, but 6734 for failing to comply or not fully complying with a request for public records, and for willfully failing to discharge the duties. And it's pretty serious stuff. I mean, this body doesn't take lightly to make determinations on willful misconduct. I don't like to do it. But sometimes it has to when things aren't happening the way they should be. When did we receive the response? It says the committee requested the respondent provide a written response.
Yes, you submitted one on July 26th. She was here.
July 26th.
On behalf of the office. I was out of town that day.
Okay. Through the chair, Mr. Lim, if you were, you obviously touched this request at some point, if not at the very beginning, and we sent you several memos and emails asking you to be present, etc. What prohibited you from going back months ago, seeing there was no evidence responsive to this request, and drafting a written statement to that effect as required by the law?
Unfortunately, I think for this particular request, we just did not process it properly. But moving forward, we take all the requests very seriously. If you've seen the recent ones, we've tried to respond immediately within the time frame.
With all due respect, I think if you'd taken any of this seriously, you would have showed up to several of the previous meetings, and you chose not to do that. There's pretty clear interpretation to me what that means, but I've been part of this case from the very beginning in all its different forms, and I'm a big fan of Eric Mars, but you've kind of left us no choice here.
Well, like I said, we're trying to do our best moving forward, and Ms. Yu has also helped draft some good policies, implementations that we're working together in this office to improve our response.
No further questions.
Member Josh Wolf.
Just a real quick clarification on what you just said. If I heard you correctly, I believe you just said we've tried to meet all of the responses immediately, within the allocated time frame. Right? I don't know whether you use the word allocated. How many of the past...
I should be more clear. I'm talking about if you look at the ones that's coming in August.
So how many of the IDRs in August were responded back within the next business day as required under the law? Or how many weren't, more specifically?
Deputy Counsel, can you define the response times for these IDRs?
24 hours.
Okay. Well, We tried to respond, but it was also our legislative recess. We responded on the 28th. The request came in on the 18th, 17th, and 16th of this month. But our office was closed at the time. We had minimal staffing. So whoever was on duty was doing their best, and that was Miss Yu trying to respond. I was off with medical leave the entire month of August.
Great, thank you.
Any other questions? Discussion, debate? Is there a motion?
So I have a question.
Yes.
So as far as 6734 goes, do we have the jurisdiction to do that, or do we have to pass that on to the Ethics Committee to handle? Because, I mean, reading through the ordinance, it says complaints involving allegations of willful violations of this ordinance, the Brown Act or Public Records Act by elected officials, department heads of the city and county of San Francisco shall be handled by the Ethics Committee.
Right, so the enforcement gets handled by that, but our determination, we will make a determination that there was willful violation, and then we'll immediately send that over to the Ethics Commission, and they have a whole process that the task force developed with them back in, I think it was late 2012, or early 2012, that finished in late 2012. So they have a whole process for that already.
So this is consistent with what's gone before?
If the members of the Sunshine Ordinance Task Force wants to find a willful violation, they may, and there's a process that proceeds from there.
Okay. And this would be against Supervisor Marr and not staff or department heads or anything like that?
If you read Section 6734, it is specific as to who is the responsible party.
Okay.
Through the chair.
Vice Chair Hyland.
And the Ethics Commission, I believe I'm correct in saying this, will convene a de novo hearing and look at all this from the beginning. Is that correct?
Yeah.
Yeah. That's kind of how it works.
All right. So, thank you, Mr. Lim.
Thank you.
Motion.
There is a motion.
I think there's a motion.
There is a motion.
Already,
Okay.
and a
Great.
second.
Okay. Let's call roll. Oh, we need public comment.
Can you repeat the motion?
The motion is to adopt the recommendations of the committee to find additional violations of Section 67.21E and 67.34.
Thank you. I didn't make a motion on this.
I think you seconded it.
You seconded
it. Sorry. Just wanted to make sure I understood. We had been a little while since we had done the motions on this.
Okay.
I was confused as well. There we go.
All right, everybody clear where we are? Okay,
Thank
great.
you.
Call the roll.
Public comment.
Oh, public comment, I'm sorry, yeah. Public comment on this item. I did say that.
Peter Warfield, Executive Director of Library Users Association. We're not a party to this, but I have to say that personally I'm disappointed in Supervisor Marr. And as I understand it, there's been every opportunity provided by the complainant and this body for the supervisor to respond multiple times. I believe there was a particular letter, which perhaps Vice Chair Hyland remembers, with respect to alerting the supervisor to the possibility or the likelihood of a 67.34 finding if he didn't respond to a specific request. So there's been every opportunity given to the supervisor to respond under the law, and I'm very disappointed that the answers to what happened are that we're doing everything okay now, which doesn't seem to be a response at all. So certainly I support your motion. Thank you.
Any other public comment? Seeing none, public comment is closed. Call the roll.
On the motion, Member Baranetsky.
Aye.
Baranetsky, aye. Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Corporate absent. Tesfa, excuse. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hensy.
Aye.
Hensy, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes. Would the committee like me to draft a referral letter for approval of the chair? Or would the chair like to draft that letter, the referral letter to the Ethics Commission?
Doesn't matter. Do you want to, I wasn't party to it at that time, but here we are.
Through the chair, yeah, Victor, if you could draft and then send it to Bruce and I for approval, that'd be great.
Okay.
That will be taken care of.
Thank you.
Would you like to take a break before we move on?
Yeah, let's take a, what time is it? 22. Let's take a 15-minute break. We'll be back at 8:50. We're in recess. Let's call next item.
Next on the agenda was item number 9, which was withdrawn. File number 16026 was withdrawn by the complainant. Next on the agenda is file number 16048, complaint filed by Anthropo against the Fine Arts Museum for allegedly violating Administrative Code Section 67.16 for failing to post meeting minutes online in a timely manner. On July 26, 2016, the Education, Outreach, and Training Committee referred the matter to the task force with recommendation to find jurisdiction and to find that the Fine Arts Museum violated Administrative Code Section 67.16 by failing to post various draft meeting minutes online within 10 days of the meeting. The respondent acknowledged that the meeting minutes were not posted within 10 days of the meeting and has taken steps to ensure the mistake does not occur again. In addition, the Fine Arts Museum has stated that they will be improving their practices and will be posting their draft minutes online due to the large gap of time in between their meetings.
Okay, so EOT, you want to take this?
Yeah. Member Kanata, go ahead.
I mean, we found the violation. The respondent admitted that they didn't do the processes properly, and that's why the violation was found.
Okay, great. All right. Is both the complainant and respondent here? Okay, great. So do you have any comments you want to state? Okay, go for it.
Okay, 3 minutes. This is the one about the posting of the agenda and the minutes, right?
Mm-hmm.
Okay. So I just noted that before I even filed my complaint, they certainly were aware that they had sunshine issues because in their January 26, 2016 minutes, they have a section which was tabled where they were going to be educated on the Sunshine Ordinance. So, and then you have to understand there are 47 trustees. That's a lot of people. So I just wanted to throw this out there. I think there was a big awareness about this. Going way back, Aideen Vera was their deputy city attorney for many years, and it seemed that she allotted a lot more time to the Fine Arts Museum than the War Memorial or the Arts Commission. So I think they certainly were aware that they had regular training sessions, and why did this happen? I don't know. And then there's another issue that I wanted to bring up. Once again, they have an enormous, when they have a meeting, there's trustees that are present, there's trustees who are excused, and then there's some who are on the phone. And this I wanted to bring up because when someone is listening in, they don't have a vote, but they also shouldn't participate in the meeting. They should just be there listening. And that is nowhere that I could find in the ordinance. And this is very common with their trustee meetings. And I think that, if you want, you could talk about that, because it's a pretty common occurrence with them. That's it.
Thank you. Respondent?
Good evening. Megan Bourne from the Fine Arts Museums. Mr. Young fairly summarized the meeting from July, and I would only add that it was not the museum's intent to violate the Sunshine Ordinance. It was essentially my understanding that the meetings were to be posted after they were finalized, and when this was brought to my attention, starting with the June meeting, we are now posting draft minutes. So it is absolutely our intent to meet those requirements of the Sunshine Ordinance.
Great. Is that it? Thank you.
That's it. Thank you.
Okay. Members?
Motion to approve the recommendation and with the chair's agreement, recommend no further action.
Okay. Is there a second?
Second.
Moved by Vice Chair Hyland, second by Member Hinsey. Public comment.
Ray Hartz, Director, San Francisco Open Government, and thanks for the long break. I got to go back down and make public comment at the Police Commission meeting. I support the recommendation of the committee and hope that the full task force will pass it. I think that there's an old expression that we judge others by their actions and we wish to have ourselves judged by our intentions. Unfortunately, sometimes when people bring these kinds of motions or kinds of complaints, the perception is that it's some sort of heinous thing that they're doing just to make everybody's life miserable. And unfortunately, it sometimes is the only way that certain bodies are made aware of the fact that they are not acting lawfully and are put in a position where they are, in many cases, as it seems in this one, when they're made aware, they make an honest effort to repair this situation and get within the bounds of the law. And then there are others who basically want to come up with 105 reasons why they shouldn't have to. So I think in this particular case, the intent was clearly to ensure that for all members of the public that the necessary work was done and it was posted as the law requires.
Any other further comment? Public comment? Seeing none, public comment is closed. And members, any last words, items on this? Seeing none, please call the roll.
On the motion, Member Baranetsky.
Aye.
Baranetsky, aye. Member Eldon.
Aye.
Eldon, aye. Member Wolf.
Aye.
Wolf, aye. Copra absent. Testify excused. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Next item, please.
Next on the agenda is item number 11, file number 16049, complaint filed by Andrew Bowe against the Fine Arts Museum for allegedly violating Administrative Code Section 67.26-6 by failing to disclose source of outside funding over $100 on the department's website. On July 26, 2016, the Education Outreach and Training Committee referred the matter to the task force with the recommendation to find jurisdiction to find that the Fine Arts Museum violated Administrative Code 67.29-6. The committee acknowledged that some donation information is listed on various meeting minutes of the Fine Arts Commission. However, the committee determined that donation information should be posted on the department's website as a separate document listing dollar amounts, sources, and other information required by the Sunshine Ordinance. Ms. Bourne requested time to consult with other stakeholders to determine how and if the Fine Arts Museum can comply.
Mr. Bowe? 3 minutes.
Once again, I had no bad intent in filing this complaint. I spent a lot of time looking at it. I realized that it would be a complex thing, but you can understand that the need for transparency after what transpired with a Attorney General investigation, a whistleblower complaint, a couple front pages of the Chronicle and the New York Times. I mean, to have a president of a major museum resign or, to amend the bylaws to prevent a lifetime tenure for one person to be president is amazing to me. I can't even comprehend that, but I believe that it will take time for this for them to conform to the Sunshine Ordinance. It won't be an easy task, and but I think that they'll be able to do it. It'll take some time.
Respondent?
Thank you. So the Fine Arts Museums has requested an opinion from the City Attorney's Office on whether FAM-SF, the city agency, may accept gifts from COFAM on the condition that FAM-SF not disclose the corporation's donors under the City Charter 5.105. And if there's going to be a vote on a finding tonight, I would request your consideration for continuance of this item. I did just kind of, as we discussed in the last meeting, do a little bit of, actually not, from some research on the impact or of listing the 34,106 donors in our last year. With our current protocols for donor recognition, it takes about 1 month for us to approve, because we try to be very meticulous about accurately reporting, to approve the quarterly members, for the Quarterly Members magazine, a donor list of about 2,000 names. And we are also very concerned about the need to maintain the privacy of donors who wish to remain anonymous. As I stated in July, we do acknowledge at virtually every FAM meeting funding expended by COFAM on behalf of the Fine Arts Museums, and we do publish COFAM's annual report on our website, which lists by name all donors of $1,000 and up, which I note is the practice of some other city agencies which receive funding through in support by a 501c3. Thank you.
Thank you. Members? Vice Chair.
Through the chair, Ms. Bourne, did I hear you ask for a continuance? And
Yes.
Okay.
Yes.
I think, based on the what we heard before, the recommendation is for violation, which I guess has already happened. So I'm just I think what we would hope is that in the future you would be able to comply more. I guess more in a more timely fashion to reporting, future donations. Am I understanding that correctly?
Let me ask it a different way. You're asking for a continuance for what reason?
Well, first off, to receive an opinion from the City Attorney's Office as to whether, in their opinion, FAM-SF may accept gifts from COFAM on the condition that donors may remain anonymous.
Okay, and you hope that that will somehow provide evidence that you were in compliance with the ordinance?
Yes, sir.
Okay, so the question is whether that practice is actually in compliance with the ordinance of withholding the information.
Yes.
Okay. All right. Thank you.
Okay. Thank you.
Okay, so just so everybody is clear, the recommendation from EOT was to find a violation of Section 6729-6. And it was with some discussion, if I recall, it was pretty clear, kind of according to the ordinance, that that it's how the process is supposed to be. So I leave it up to you folks to what do you there was an opportunity for there's an opportunity for them to provide evidence that they were within the law to withhold this information. They're asking for a continuance to be able to further that determination. The question is, do you want to allow it? We can ask the complainant to. But, the law is what's in front of us. I don't know any other way to read it. So that's my view on it.
And through the chair, just to remind the task force members, we heard this in the EOTC on July 26th. So that was about 5 weeks ago.
Mm-hmm. Okay. All right. Is there a motion? Oh, we already have it. Did somebody make?
There was no motion.
No motion. So, is there a motion?
I'll move to accept the recommendations of the complaint committee.
Okay, moved by member Hensy. Is there a second? No second?
I'll second.
Seconded by Vice Chair Hyland. Public comment.
Ray Hartz, Director, San Francisco Open Government. I agree with what you're doing. Basically, there has been a violation. The only thing that I believe, from what I'm understanding from the respondent, is that the city attorney may come and say that certain donors don't have to be put up there. That doesn't change the fact that there are some that do have to be put up there, and they have not been, and therefore they're in violation of the ordinance and should do that. I don't see any need for a continuance if the city attorney later comes along and says, under the law, you may do this and that, or not disclose certain ones. I don't think it's going to be a broad thing where they say you don't have to disclose anybody. And so they should work from this point on to use all the ones that are not in question, put them up on the website, and then if they want to wait for a certain amount of time to get a city attorney's opinion about ones that are in question, that's not an unreasonable thing. But to delay the entire process, waiting on the city attorney, who may take his sweet time in issuing that decision, would be just a further continuation of the violation of the ordinance.
Any other public comment? You're a part and party. Okay, seeing no further public comment is closed.
Mr. Chair?
Yes.
Could I ask Ms. Bourne another quick question?
Sure.
Just real quick, have you presented this question to the city attorney at this point?
I have.
And when was that question presented to them?
It was today.
Okay.
Yeah.
All right. Thank you.
Yeah, thank you.
All right. Seeing no further comment, discussion, let's move to call the roll.
On the motion, Member Baranetsky.
Aye.
Baranetsky, aye. Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra absent. Tesfa excused. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hensy.
Aye.
Hensy, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes. Next on the agenda, item number 12, file number 15161, complaint filed by the Library Users Association against Laura Lent and the San Francisco Public Library for allegedly violating Administrative Code, Section 67.21, for failure to respond to a public records request submitted orally in a timely and/or adequate manner in regards to BiblioCommons webinar. On August 16, 2016, the Compliance Amendments Committee referred the matter to the task force with recommendation to find jurisdiction and to find that Laura Lent and the San Francisco Public Library violated Administrative Code, Section 67.21, by failing to respond to the February 20th, 2015 oral request for public records in a timely manner. Ms. Lent at that meeting acknowledged that she was initially unaware of how to respond to an oral request for records, but is now informed as to how to process future oral requests. However, Mr. Warfield, it was discovered that Mr. Warfield did get the records he requested from the library, but neither party could determine when those records were provided.
Thank you. The complainant, have 3 minutes, if you like.
Peter Warfield, Executive Director of Library Users Association. It was not determined that we got the records, and we certainly did not get the webinar, which we specifically requested when we saw it during a meeting with Laura Lent. As those of you who were not here previously may not know, in January, we requested the webinar from somebody else, the deputy city librarian, who told us it didn't exist. When we then went to Laura Lent on other issues, problem reports and the results, we saw that the webinar did exist. And now we were once again told she wouldn't provide the document. And that she said we had to go to the Library Commission secretary. So we view this as a refusal, and I do think it's important to make a distinction between a refusal and a delay. Laura Lent never responded to us directly on this. She said we had to start with the city librarian, the Library Commission secretary, and we had to go through quite a bit of thrashing around to get some of those documents. I have since then requested from her what she sent me initially, and it was not, there was at least one other item that we requested that was not included in her response, besides the webinar. But I think that the whole question of duplicativeness was laid aside after an exhausting hearing. And I think that basically it's a good strategy when you have repeat violations. I think the law is clear. If somebody goes and asks for a document that exists, that person has to provide the document if they have access to it, and not send you on a merry-go-round. If you'll notice, I had initially requested problem reports from the secretary. She said, go see Laura Lent, and I went to see Laura Lent, and then Laura Lent said, go and see Sue Blackman. In any case, as we said in our letter of August 31st, generally we agree that there was a violation. We asked to include the city librarian in this because he certainly ought to inform his senior administrators what the law requires, especially after many violations in the past. And we would like that included. Also, a specific reference to BiblioCommons records, including the BiblioCommons webinar of January 2015.
Okay, thank you. Respondent, 3 minutes.
I do not believe there's a member of the library here today.
Are they here?
They are not.
Oh, they are not. Okay, great. Okay, so members, somebody from CNA want to make a motion?
Yeah, I move that we find from the request of the committee.
Second.
Moved by Member Kanata, second by Member Hinsey. Public comment.
I ask that when you write an order that you include in it where, if it was going to be referred to a subcommittee, where it was going to be referred to. So it's very clear on both parties. Like in my previous case, I was kind of left hanging. I sort of thought the thing was just going to die. So if you put on the record exactly what your intentions are.
Just so you know, we always do that, and
Yeah.
in your case, the previous motion was that no further action be taken.
On the website thing?
Oh, no, right now, when we made the motion in the previous case.
No
in your
further
case.
So they don't have to reform their website?
It's not our requirement to do that. I mean, it's like we found not to refer to committee. But we always do. At the end of every motion, we'll either determine whether it needs to go to a committee or not, or whether it does not need to go to a committee.
Oh, all right, thanks.
Ray Hartz, Director, San Francisco Open Government, and again, I support the motion. Mr. Warfield is one of the few people that goes to Library Commission meetings and actually reads and studies and asks questions about some of the things that go before them. Unfortunately, the Library Commission members seem to be totally without a clue about many of the things they pass. A case in question is they just had approval at the last Library Commission meeting of a resolution to spend millions and millions of dollars to buy a property for the use of the library. And it turns out that when they were voting on the resolution, it had already been passed by the Board of Supervisors and signed by the mayor. So I don't know exactly. They're not honest people. They act in bad faith all the time. And unfortunately, between myself and Mr. Warfield, we're establishing a pretty clear record that the individual most in charge of that is Luis Herrera, who I believe directs other employees of the city library to act in ways that are contrary to the law. In one particular case, he did that in a case I had where I was asking for public records relating to monies he had received from the Friends of the Public Library, and he was found to have violated state law by the FPPC and had to pay fine, and he committed perjury for 3 years, and the only reason it was limited to 3 years was because that statute of limitations had run out on the prior years. So basically, I believe the library needs to get a very clear understanding that they do not follow the law. And honestly, I would like to say that I believe it's ignorance on the part of somebody, but it isn't. I think it's just basically they know what the law is, and they will put up as many roadblocks as possible to block access to public records because they don't like the fact that we use those public records subsequently at Library Commission meetings to question some of their actions or some of the instances where they fail to act.
Okay, any other public comment? Seeing none, public comment is closed. Any other comments? Members? Seeing none, please call the roll.
On the motion, Member Baranetsky.
Aye.
Baranetsky, aye. Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra, absent. Tesfa, excused. Member Moss.
Aye.
Moss, aye. Member Kanada.
Aye.
Kanada, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Please call the next item.
Next on the agenda is item number 13, file number 15162, complaint filed by the Library Users Association against Deputy City Librarian Michael Lambert, City Librarian Luis Herrera, and the San Francisco Public Library for allegedly violating Administrative Code Section 67.21 and 67.22 for failure to respond to a public works request submitted orally and by discouraging staff from providing information orally in a timely and or adequate manner in regards to bibliocommons. Respondent testified that Mr. Warfield was not barred from contacting individual staff members provided details of past meetings with Mr. Warfield. However, due to the limited resources and the technical nature of bibliocommons and with the advice of the Office of the City Attorney, Ms. Lent was designated as the primary contact person. Upon review of the testimony and the submitted documents, the committee does not believe that Mr. Warfield was restricted from contacting various members of the public library staff. In addition, the committee believes that the designation of Ms. Lent as a point person for Bibliocommons questions and setting a 15-minute limit is allowable under Sunshine Ordinance Section 67.22.
Okay, complainant, 3 minutes.
Peter Warfield, Executive Director of Library Users Association. First of all, I did fail to mention earlier, thank you to the chair for having these hearings on these two items, which had been denied a hearing last December by the task force. There are two unique things here that I think are very important. We disagree with the finding of the subcommittee. I believe that Chair Kanata thought that this would go to a full hearing at the full task force, but apparently it's not. And I wasn't aware of that either. This is my first time at a subcommittee rather than at the full body. I think the law is very clear. Section 6722E says, notwithstanding any other provisions of this ordinance, public employees shall not be discouraged from or disciplined for disclosing any information that is public information or a public record to any journalist or any member of the public. I'm certainly a member of the public, and I'm also a journalist and have written about Bibliocommons in a way that certainly was something that the library wasn't happy with, and was written about in opposing some of the very serious privacy issues with Bibliocommons that are posed to the patrons of the library using it. The supposedly helpful memo that Mr. Lambert sent to some senior people, along with the Sue Blackman memo that said the city attorney told us he can't just call around, and is limited to 15 minutes, though it didn't say per what. We heard testimony that was brand new to me that the city attorney supposedly advised them that I can get 2 hours a week. And there was no clarity about 15 minutes per what? Per day, per person, per issue? The law also, I don't think, requires that. So let me say that I was never given the Lambert memo, which was supposedly supposed to help me with getting information. I don't mind if they want a point person for people who don't know who to ask, but there were two people that I was very particularly interested in speaking to, and I was denied access to them. One of them said specifically that she had gotten a memo, and that was why she wasn't talking to me, even though she had previously spoken with me freely about questions that I had. I wanted to talk with the catalog person and the web person. So I don't think it's appropriate that there has to be a proven effect when there's a memo of discouragement. And I think that my testimony was discounted or ignored, where I showed that there were examples of people not speaking to me and who were intended to be denied. And the claim of the chair that people are entitled not to respond to requests for information, which I think is very wrong and would undermine basically all of the Sunshine Ordinance if people could just say, oh, I don't feel like responding to you. So I would like to have this heard by the full body, and certainly not an approval of what was recommended. I particularly appeal to the journalists among you and the lawyers among you. Thank you.
Respondent? The respondent here?
There is no respondent present today.
Oh, okay. Members, what shall we do?
Through the chair, Chair Wolf, Member Kanata, and myself were there, and I think all the people that would come up in a full hearing from the respondents' side did appear before us. I think there was 2 or 3 individuals, if I remember correctly, and they all categorically denied there was any formal policy, written or otherwise, to not speak to Mr. Warfield. It certainly seemed convincing to me at the time. And we did spend quite a lot of time on that issue and sliced and diced it, I think satisfactorily. And that's part of the purpose of the complaint committee, to kind of get into it and look at things, and that's the basis of our recommendation.
You have anything to add, Member Kanata?
No, that's succinct.
Okay. Member Josh Wolf.
So I'm not doubting the record of what happened in the complaint committee at all, but at the same time, when we created this complaint process, part of what we had instantiated, or at least discussed in the time, was that if a complainant does not want to go through the complaint process, that they have the opportunity to be heard by the full task force. I don't know whether Mr. Warfield had asserted that wish prior to the complaint hearing, at which point this would be a little bit more straightforward, but he certainly in text has argued that he should have a hearing before the full task force. The respondent isn't here to address any concerns that people may have based on what's written, and so I would be in favor of continuing this and scheduling it as a hearing before the full task force.
Through the chair.
Vice Chair Hyland.
Mr. Clerk can probably speak to this. I believe on the form where people are given the option to appear before the complaint committee, there's a checkbox that says...
I don't believe there is any checkbox. It's just the determination is made by the chair whether or not to refer matters to the complaint committee or to the full task force, and we do take the request of the complainant into account.
Okay.
However,
where did I see that checkbox? Was it on the...
It's for hearing. It's an older application
Okay.
in which whether or not they want to have a hearing or not have a hearing, which does not apply because everything goes to hearing. And I believe at several meetings ago at the Sunshine Ordinance Task Force, where we heard the request from Mr. Warfield to hear these complaints, it was determined by this task force that the complaint committee would hear it and make a determination as whether or not it be duplicative or not, and to hear that matter.
Right.
It's been a standing, since I've been involved with the Sunshine Task Force, it's been a standing policy if the complainant requests to have it heard by the full task force and not by committee, that usually that wish is granted.
So through the
at
chair.
the time of complaint. But in this particular case was a somewhat of like a reconsideration of a very old case. And so we had decided to allow it to be reheard as two individual items at the complaint committee level, and to have it found if it was duplicative or not. Obviously, it wasn't found not to be duplicative, and we are now here with these recommendations from the committee.
Through the chair, just to play this out, let's say we've put forward a motion to accept the recommendation. A second, it's voted on, and the case is closed. Mr. Warfield still has the opportunity to represent this as a brand new case and kind of get back in line, so to speak.
Within whatever, and I've not reviewed it in a while, if there is a reconsideration process, then yeah. If he does not agree.
Our procedures state that within 10 days of the issue of the order of determination, the parties can request reconsideration, but only if there is new information to provide. And they would have to make us provide evidence that there is new information.
Right, and I yeah.
Hold on a second.
Go ahead.
Member Josh.
I have a question for Victor through the chair, I guess, is
Yes.
how that would work.
Right.
So Chair Wolf just spoke of if a complainant makes a request at the time of the complaint to be heard by the full task force instead of the complaint committee, that it's usually honored. Was that the language you used, Chair Wolf? So in the case of Mr. Warfield, who probably has a little more experience in how the Sunshine Task Force works than other complainants. Potentially, I can understand a different expectation of the learning curve, but I'm curious, both in the case of Mr. Warfield and other complainants, whether they're notified of the opportunity to request a hearing in front of the full task force as opposed to the complaint committee.
I don't believe that option is offered.
Great, thank you.
May I say something?
Does it pertain to the motion on the floor, or there is no motion?
I wanted to correct some facts.
With regards
the body did not determine that it would go to the Compliance and Amendments Committee. Bruce Wolf urged the then acting chair to go to a hearing, and then, as chair, proposed to me in the room that it go to Compliance and Amendments. And because there had been months of scuffling over an undocumented, so-called duplicative process and how the thing had been rejected for a proper hearing, in December, I said, okay. I did not realize that it would possibly not go to the full body. I've had all of my complaints in all of 20 years of filing complaints go to the full body, including in the past when Complaint Committee and Compliance and Amendments would send things forward for the purpose of clarifying, but not for the purpose of substituting for a full hearing. And there's no written procedure on this.
I understand, but this particular issue was that because the item had been heard before, an opportunity was granted to have it heard again.
It was not heard before, and you heard Vice Chair Hyland say at the hearing in four words and no apology that all that stuff was it was withdrawn. It was not ever heard previously.
Mr. Warfield, I apologize. So those items were withdrawn at the time. I recall now.
Yeah, so we saw these items in packets. They were then withdrawn on the day of, so that's why it's confusing as to whether it's there or not. Mr. Warfield, I have a quick question for you. Clearly, you were there at the compliance meeting, and you heard the respondents' answers. Did you feel it was not adequate? Do you feel that you would get a different response by having them come out again before the full task force?
Absolutely. I would certainly hope that the journalists here and the attorneys here, as well as the folks who are unclear on the law, as Chair Kanata said he was, that they would have a chance to study the law and to study what I had presented.
Please answer my question. I thought we asked some pretty incisive questions to the people that were here. I'm forgetting their names, but all the people that you named in the complaint, they stepped up. They said, no, absolutely not. We didn't do this. We didn't issue this memo. We didn't issue this policy.
We didn't issue this memo. It's in your packet. They issued the memo. I don't know what you're talking about. They made a bunch of excuses about what they intended and how they planned on being helpful, and it was complete nonsense.
In your opinion?
They issued a memo that actually resulted in my not being able to speak to the very people I wanted to speak with. They gave a lot of talk about all the people that had been provided, but not the ones I wanted.
I am not going to allow back and forth like this. Okay, there's the recommendation of the Compliance and Amendments Committee was to find no violation. If any member here wishes to seek to find a violation and wants to move ahead in adjudicating this, that's in your desire to do so. Okay? I'm not going to argue process here.
I don't know what you mean, what the meaning of what you just said was.
So this item was brought before the Compliance and Amendments Committee. Okay? The Compliance and Amendments Committee found no violation. Okay? That's the recommendation that has been brought to you. If you feel otherwise and you want to adjudicate it, then let's do that.
To the chair. So if we have the motion to adopt it and vote on it, if you vote no, you're basically voting to potentially have this heard by the full task force. Is that correct?
Well, there's no, the recommendation is to find no violation.
Or to reject the recommendation, I should say. So if you reject the recommendation,
right,
you are ostensibly saying
that's right.
You would
we
like
start
to
the
hear.
process of a regular hearing on this.
Does that make sense?
And that would be a vote, not just one person doing it, right?
It's a vote, yeah.
Right, yeah. We do this all together, always.
And what's
right. So recommendation is for no violation. Okay, so if you vote in favor of the recommendation, you're saying that no violation happened at all. If you vote against the recommendation, you're just stating that you don't agree that there was no violation, and then we will move directly into the regular hearing process.
And through the chair, what passes the vote? Is it a simple majority, or is this?
It's as it always is. It's our 50 plus 1 of all members seated. Yeah.
I would like to make a motion to not accept the recommendation.
I think you can. I'm not sure you can do that.
Isn't that exactly what we just discussed?
The recommendation is to find no violation.
So
right. So I'm making a motion to not accept the recommendation.
Okay.
Isn't that the correct?
Well, it would be the task force moves.
Or to
you can make any motion you want. It's okay.
What?
Just vote no.
Just vote no.
Yeah. The motion would be that the task force finds no violation. If you vote no, then you're saying that you don't agree with that.
Request the chair to have a few comments about it.
It kind of
and we
already
can all
is a
vote.
motion on the floor, basically the
But
recommendation.
no one made the motion to accept the recommendation. So,
Right.
So if I make a motion to not accept the recommendation, isn't that a legitimate
That's fine.
motion?
It is. Yes, I'm not denying that. I'm just clarifying what other people are trying to say. You make any motion you want.
Could you
Go ahead.
explain more as to why you're making that motion? I just want to hear your thoughts.
I mean, essentially, I'm making the motion for two reasons.
Actually, I would prefer we stick with the proper Robert's Rules process. Let the motion be made and seconded, then have a time for debate, and then you can decide. People can decide whether to vote it up or down at that point.
Okay, so has the motion been made?
I understand, but that should come at the
That's
time.
fine.
So-
You never should have to. By members, you never have to explain why you're making a motion.
Okay,
you just
so
make
he's
it.
made the motion.
Did you make the motion?
has
I
been
have
made.
made this motion.
I second the motion.
Okay, so the motion is.
He just seconded.
Member Moss seconded it. So the motion is not to accept the recommendation of the committee. The recommendation of the committee was to find no violation. Is that clear? Everybody clear? Okay. All right, now you can ask your question.
Could you please explain your thought behind making your motion?
Sure. There's two things going on. One, part of the way that this complaint procedure needs to work is that if as Chair Wolf just described, there is a choice that is usually followed on the complainant to choose whether or not to be heard by a complaint committee or the full body. When I spoke to Victor about that, it became evident that that's not a piece of knowledge that's passed on to the complainant. At the point that was established and Mr. Warfield expressed a desire for it to be heard by the full task force, those two things in working together is half of the reason I'm making my motion. The other half of the reason I'm making the motion is that there still seems to be facts that are in disagreement between our committee's recollections of what happened and what Mr. Warfield's describing. I would like to be able to ask the library staff to help clarify that, but they're not here. Therefore, the only pathway available is to do a de novo hearing.
So I want to make a correction. When I made the motion to have this item be heard in committee, there was every opportunity for the complainant to reject that and say, I want it to be heard by the full task force. Okay, so it's not that just because he's requesting it or had desired it now. There was an opportunity a long time ago for that to be made, and this was brought back not by a regular process. It wasn't. I mean, this goes back to December before I was even here. So I don't know really what transpired. I mean, I've got a lot of information about it that I could piece together. But for me, at the time, even before I was chair, was just let's just get this ball on the road, and let's see what happens. There was agreement from Mr. Warfield at that time. He seemed okay with having it to go to committee, and that's where the process was. If this was being reintroduced from scratch, it would be a different opportunity because most of the time he doesn't go for committee. So, but here we are, and now, if your desire, we'll move into having the regular process, so that now it'll be heard by the full task force, and that's the way the current complaint process is operating, well or not. That's the way it's currently operating. If there's a desire to reject the committee's findings, and because one or the other parties feels that it wasn't the right decision that came out of the complaint, then you move to then the task force says, I want to hear the whole thing. That's basically the process. Did I explain that? Okay.
Yeah, I think you explained it fine. Okay. There's no point in us going back and forth.
Okay, great. Okay, so now we will move with the regular process of hearing this item. So we will give the complainant 5 minutes.
Wait, no.
What?
Wait, stop. Vote on the motion.
Voting on, sorry. My
Public
bad.
comment on the motion.
I got it.
Wait, okay, I have a question.
Yeah.
I don't think we can hear it tonight because the respondent isn't here.
I understand that, but let's get through the motion first, and then if we want to make a motion to continue the item, then we can do that.
Okay.
Okay, because otherwise I'm just going to move forward with it. So,
but we've never done what the way that you're describing.
I know, and it's an unusual situation. It's not this is something, it's a unique situation. This is not regular process. So I'm trying to guide you into a process that is proper.
So,
as chair, that's my job.
Can I ask a question?
Yeah, you can.
So historically, when we've not accepted the recommendation of the committee, what happens is it's rescheduled as a hearing and the people are re-notified.
I understand that, but I'm chair and I do things a little differently.
Okay.
Okay.
Through the chair, can we clarify the motion before we vote on it?
So the motion is not to accept the recommendation of the committee.
So I feel like I'm in a double negative world here.
I know.
So a yes vote means we
don't accept.
A no means we agree with the three-person committee. So.
Correct.
Through the chair, I just want to provide a little more perspective, having been here when the cases that revolve around this incident, the BiblioCommons incident, happened. We've spent, and it's never too much time to spend to find, to get to justice and find violations. I felt that at the last committee meeting, due process was served very adequately. I feel all the respondents that needed to be there were there. I think their answers were convincing, and I thought that the committee reached a good recommendation. Just putting out there to balance, what else you've heard here today. I think Mr. Warfield's appeal to the lawyers and the journalists is certainly clever, but I don't think that due process has been violated in this case. That's just my personal opinion.
Public comment.
Members of the task force, Ray Hartz, Director, San Francisco Open Government, and I was at that hearing, and I believe Member Wolf has it right. There should be a full hearing before the task force. The reason I say that, if you look in the Good Government Guide, again, of the roles of commissioners. Due process requires fair adjudicators. Commissioners must listen to the evidence presented before making decisions and base their decisions on the evidence in the record before them and on governing law. Unfortunately, during the hearing, number one, I do not believe that Mr. Warfield was given in an understandable way that he could have a hearing. He was simply trying to get a hearing for something that he had been denied a hearing on and was probably grasping at straws and took whatever he was offered. Whether that was wise or not, or whether he really understood or not, I can't say. I will, however, say that just as he has attempted to do tonight, Member Highland spent an immense amount of time during that hearing trying to justify the prior action rather than listening to the evidence and considering the evidence that was presented and considering that fairly. I also had to take exception to a comment that the chair made, which he said, well, maybe Ms. Lent didn't want to talk to you. That was not a fact. It was completely conjecture. And I do have to agree with Mr. Warfield that if you allow people to simply say, I won't talk to you, that is not going to further any benefit that the Sunshine Ordinance or the Brown Act or the California Public Records Act offers to people. And I said this at the time of the hearing when a senior member, and that was Deputy City Librarian Lambert, sends out a memo to the entire senior staff saying, Mr. Warfield needs to talk to a particular person. It is not unbelievable that some of them would choose to read that as a don't talk to him, send him to that particular person. And I agree with Mr. Warfield. There are some questions which cannot be directed to a particular person because they do not have the knowledge, expertise, or whatever to answer that question. And as a result, by simply saying, well, it's all right for the library to direct him to one person, and if that person can't answer the question, he's limited from going to the other people, is basically just saying, well, you can't have the information. And unfortunately, my experience with the library is they will do exactly that same sort of thing. And the fact that the Deputy City Librarian, the Secretary of the Library Commission, and Laura Lent were all three here, basically it was a round robin of we didn't say that, we didn't do that, we didn't take that interpretation. But again, how many people are going to come out and admit that's exactly what we did?
Any other further public comment? Seeing none? Members, any final words? Okay, seeing none, move to vote.
On the motion to not accept the recommendation of the committee, Member Baranetsky.
Aye.
Baranetsky, aye. Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra absent. Tesfa excused. Member Moss.
Aye.
Moss, aye. Member Kanata.
No.
Kanata, no. Member Fisher.
No.
Fisher, no. Member Hinsey.
No.
Hinsey, no. Vice Chair Highland.
No.
Highland, no. Chair Wolf.
No.
Wolf, no. The motion fails.
Now do we have to make another motion to accept or?
Well, the committee found no violation. So if there's a motion to,
okay.
there's no
Got
need
it.
to take
Got it.
take a motion. The item just fails. Okay, next item.
I'm just processing
Okay.
a moment. Thank you. The recommendation of the committee is accepted in that there are no violations of Sunshine Ordinance Task Force, of the Sunshine Ordinance, Chapter 67, as related to file number 15162. Next on the agenda, File number 16050, complaint filed by Anonymous against Director John Rayam and the Planning Department for allegedly violating Administrative Code, Section 67.25 and 67.32 by failing to respond to an immediate disclosure request in a timely and or complete manner. On August 16th, the Compliance and Amendments Committee referred the matter to the task force with a recommendation to find jurisdiction and to find that Director John Rayam and the Planning Department violated Administrative Code 67.25A and B by failing to respond to an immediate disclosure request in a timely manner and by failing to request an extension of time to respond in an appropriate manner. Upon review of the testimony and the submitted documents, the committee stated the Planning Department requested the request for a 14-day extension was invalid. Pursuant to Sunshine Ordinance Section 67.25B, requests for extension is limited to 10 days. There were issues related to the method of response, as the complainant can wish to only receive information via the U.S. mail. The committee requested that the Planning Department communicate with their staff that the requirements of Sunshine Ordinance Section 67.21B states that public records requests may be delivered orally or in writing by fax or postal delivery or in email. In addition, care should be taken to honor requests of the public to provide a response via those specified methods. Okay. I do not believe that either party is here today. Is there a representative from the Planning Department or Anonymous?
Seeing none. Okay, well, we can do this in absentia. The committee thoroughly went through this, did find violations, making a recommendation. Do I hear a motion?
Motion to accept.
Moved by Member Hinsey.
I'll second that motion.
Seconded by Member Hamas. Somebody want to make a little presentation on it? No? Okay, so I just want to quickly say this is an interesting case. I found that the Planning Department had taken an idea. What?
Point of order. Keep your voices down, please. Thank you.
The Planning Department had decided on their own to change the status of an IDR into a regular standard request, and then when asked for an extension, determined to take 14 days and not the required 10 days as stated by state law. I found that to be interesting because I recently just made a request of the Planning Department and got the same exact form letter. And so I am actually going to reach out to Director Rayam to have a little conversation about this because it's not an appropriate practice. And I would rather address it to him directly and get it corrected than to have a barrage of violations and complaints come rolling into our agenda. If after I have that conversation with him, it continues, then we'll deal with it at that time. But I found that to be a very interesting situation. So I just did a little context for this. Okay, public comment. Seeing no public comment, members, any last? Okay, let's move to a vote.
On the motion to adopt the recommendations of the committee, Member Baranetsky.
Aye.
Baranetsky, aye. Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra, absent. Tesfa, excused. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Next item.
Next on the agenda, file number 16058, complaint filed by Mirka Morales against Gregory Slocum and the Department of Elections for allegedly violating Administrative Code, Sunshine Ordinance Section 67.21, by failing to respond to requests for public records in a timely and or complete manner. This is a new complaint before the committee. Before the task force.
Okay, great. So we're going to go by the regular process. Just so everybody knows, the complainant has 5 minutes to present his or her facts of evidence. There will be an opportunity for witnesses or other parties to the complainant to have 3 minutes. Then the city respondent will respond. There'll be, if there are any parties or witnesses on behalf to support, they will have 3 minutes, and then the matter will come to the task force. Once the task force is done with its deliberations and questions, there will be 3 minutes each for rebuttal of the respondent and the complainant. Then the task force will make some additional deliberations, seeking to either make a motion or not make a motion. And then if a motion is made, then public comment will be allowed for 3 minutes each. And we'll need to go through jurisdiction first. So is there a motion to find jurisdiction?
Second.
Moved by Chair Hyland, second by Member Hensy.
There you go.
Vice Chair Hunt.
Okay. Any Member Wolf? Josh Wolf.
Yeah, so I don't know whether so Mr. Simpich, who is, I guess, either working as an attorney or working on behalf of the complainant, I've worked with in an activist capacity some 10 years ago or so. So I don't think there's a need to recuse myself, but I did want to put that out there in case there were any concerns.
Okay, great. Any members have any concerns or problems with that? Seeing none, okay, moving forward, thank you for the admission.
Since I don't know him, is Mr. Slocum in the room?
I'm right here.
Here, okay, so both, and it's the respondent here?
I'm not here. I'm John Arndt, I'm the Director of Elections. I'm here.
So Mr.
Okay.
Slocum is not here?
Yes,
I was referring to Mr. Simpich.
I know, but I have a thing with Mr. Slocum, but he's not
okay.
here, so I don't have to bring it up.
Okay.
Not that kind of a thing.
Great.
All right, so I do not need to.
Okay.
We've spoken on the phone multiple times. I just wanted to throw that out there.
No problem. Do you feel that you would be biased or?
Absolutely not.
Okay.
I'm ready to go.
Perfect, great. Okay, public comment on jurisdiction. Seeing no public comment, let's move to a vote.
Would you like to take that without objection?
Yeah, we can do that. Okay, great. Motion passes. Okay, let's move with the process. Mr. Morales. Is that right? Morales?
Berker Morales is my client. I'm Bill Simpich. I'm representing him.
Oh, you're representing him. Oh, okay. Okay, well, whoever the complainant is to make your testimony, please step up to the podium.
It's a graphic video.
Hi,
How you
I'm
doing?
Mirka Morales.
You have 5 minutes.
I submitted a request for how many provisional ballots were received on election night, June 7th. And I had a few other questions that I directed to Mr. Slocum. But the one that I really was never satisfied with was my request for how many provisional ballots were received on election night by the department. And I was seeking essentially the I was a poll worker, so I knew these posted ballot statements were completed by each polling place and posted outside. So it's a public document. And then the copies of that also go to the SF elections. So yeah, essentially I had one question, which is how many ballots, provisional ballots, were received by SF elections on June 7th. That's my statement. Should I stay here?
If you have the whatever balance of 5 minutes, if there's anything
that's
else
it.
for
No,
your
that's it.
case.
That's
Okay,
mine.
very good. Are there any witnesses or parties to provide facts or evidence in support of the complainant? Please step forward. You have 3 minutes.
Thank you. I'm Bill Simpich. I submitted on behalf of Ms. Morales a document on August 30th that I think summarizes what I'm going to say, so I'll keep it brief. The bottom line here is that Ms. Morales made a request in writing on June 13th stating, I would like to request a number of provisional ballots received on election night. That's the center of the request. And what happened there was nothing, basically. There was no clear answer to that request about election night. Instead, a response was given saying, well, we'll give it to you when we're done with the count. But that wasn't her question. Her question was, election night, we want to know how many provisional ballots. And those provisional ballot statements are precisely the documents that provide the information she was seeking. So, the Elections Code 14433 and another statute that we've given is very clear, saying if ballots are counted at precincts, the precinct board immediately shall transmit a statement showing the result of votes cast at the polling place. That statement shall be open to public inspection. And it's our contention that she made it clear she wanted written documents. It was understood by the other side what she wanted, and they said, we can't give you documents at this time because we're not done with our count. So there was like a willful refusal to hear what she was asking for, and that's why we're here. Again, she's asking for those statements, and they're not that voluminous. They come from the polling places. When they're handed to her, she can add them up, and she'll have the number from election night. And it's an important document. It's not idle, but we don't have to spend our time explaining why it's so important, but I can assure you that this is a way to make sure election integrity occurs. And one other small aspect of that was she also asked for the documents that were on first pass looked at to be and scanned to get a number from those as well. And we would submit that is not as clear and not as unambiguous as her initial request. That request was a little muddier because there was another definition of first pass. They say first pass was something that was still going on. And she didn't mean it in that context. She simply wanted to know, what have you scanned as of the time of my request? And that's the only clear way you can read her request on that. Those are our two requests. There was a third request. We dropped it. Thank you.
Any other parties in support of the complainant? Seeing none, respondent, you have 5 minutes.
Good evening. I'm John Ernst. I'm the Director of Elections.
Before you start, this complaint is against Mr. Slocum. So you realize that any determination that is made by this body will be against Mr. Slocum.
Well, it's against the Department of Elections.
It's not,
It's against Gregory Slocum.
It's against Department of Elections, is that correct?
It's against both.
It's against
Slocum and the Department of Elections.
Okay, so there could be a possibility because Mr. Slocum was named. I understand that, but because the complainant named a person, that person is considered to be the custodian of records, and there's certain requirements under the Sunshine Ordinance. If that person doesn't have the documents, so on and so forth, there's a whole series of requirements for that. So I just want you to be clear. I just want to be clear that the body, because if it's against both, that obviously you're welcome here as the director to speak on behalf of the Department of Elections. But if Mr. Slocum, if it's found that he was in violation, that the task force can take that up. Just wanted you to be clear about that.
Thank you.
Okay.
So I'm the Director of Elections. Gregory, Mr. Slocum is on leave at the moment. That's why I'm here. That's why he's not appearing before the task force. So when I reviewed the complaint documentation that was provided to me, I saw 5 issues. So I'll just go through the 5 issues that I saw in the complaint as I understood it. So the first issue was that the department did not provide a number of provisional ballots that were received by the department on election night, and we actually did, and it's actually included in the complainant's package of materials, the press release that we issued. I don't forget the date, but I think the press release indicated that the department stated that we received about approximately 20,000 provisional ballots on election night. And the reason that that's an actual number is that we receive the provisional ballots, which are in envelopes similar to this one. It's not the same envelope from this past election. But we received the provisional ballots from the polling places, envelopes similar to this. And the envelopes are in a plastic bag, which are in a canvas bag, and the canvas bags have locks on them. And so, in San Francisco, deputy sheriffs pick up this material from the polling places, and then transport the bags to our warehouse, which is called the processing center on election night. So then we hire a bunch of folks on a temporary basis for the evening to work at the processing center to pull the provisional envelopes from the canvas bags, open the plastic bags, take the envelopes from the plastic bags, put the envelopes in plastic mail trays, and then we hand count those. And we received, I think, almost 18,000 provisionals on election night. And it's not the only thing that's going on at the processing center, because all the materials are coming back to us that night from the polling places. So we know from experience that hand count's it's not going to be a dead-on number. We know that. And so after I give the last results in election, I go down to the pier to our warehouse, Pier 48, and I observe the activities at the processing center to get a sense of how things are flowing. And part of the reason I do that is to get a sense of how the counts for the provisional ballots is going, because I know that I'll have to adjust the number that I get from the hand count. And I also know if the number is not close to what is the final number, there's going to be questions about the ballots and the number of ballots and how I know this. So after receiving a number from the person who oversaw the hand count of the ballots, which I don't remember, to be honest with you, I determined to issue a press release the next day. We had about 20,000 provisional ballots on hand. So that's the number. So that's my response to the first issue. On the second issue, on the number scanned, we did provide that number. And I actually sent Mr. Slocum an email with that number the day after Ms. Morales requested a number from the department. It's not a number that we report regularly, but so once I saw the request from Ms. Morales through Mr. Slocum, I spoke to the folks who run the equipment that scans the provisional ballots, and I asked them how many to compile the reports and give me a number so we could provide to the complainant. We did. I couldn't find anything today in writing that Mr. Slocum provided the number, but from reading through the complaint, the nature of the request changed from just a number to a breakdown of the number. So my sense is that we did communicate the number verbally, and then the next set of questions was a breakdown on that number. We don't create these ongoing reports as we process the provisional ballots. After the election is a process called the canvass. There's a lot of processes that are undertaken, and we're not trying to get the number right away. We're trying to go through a process to verify the ballots and to make sure there's as many ballots that are valid to be counted that we do count them. And I got to hurry up. On the first pass, that's actually getting information on this envelope, all the envelopes that came to us, and putting into the database. It's a start of the provisional review. We don't create reports on this first pass. It's not something that occurs. Posted ballot statements, we didn't receive that question. If we could provide posted ballot statements, we could have made copies. We didn't receive it that way, and we don't view posted ballot statements, which are posted each polling place, and we get another copy sent back to the department. We don't view them as the final word on what happened as far as counts are concerned at the polls, because poll workers sometimes don't fill them out. They transpose numbers, so on. So that's my 5-minute response to the issues I saw in the complaint. I can step forward by 3 minutes and reply to specifics, take questions. Thank you.
Thank you. Are there any parties or witnesses to provide facts or evidence in support of the respondent? Seeing none, the item is now with the task force. Vice Chair Hyland.
Through the chair to D.C. Icola. Quick question that you might be able to help us with. At what point does a ballot become a public record?
I don't have an answer off the top of my head on that.
Yeah, because I think that's kind of critical as to, is it when it's certified, is it when it's counted officially? I think it's in that sort of interim limbo state. I don't know, I'm just throwing that out there.
You might want to ask the director. He probably would also know that question.
Mr. Arntz,
answer that question.
If you can field that one for us.
Yeah, an actual ballot is never a public record. So
Interesting.
So a strict answer to your question would be this, a ballot itself is never a public record.
It's private. Because,
Correct.
Is it a public record?
Hold on. Taking turns. Take a stack. Okay.
so
Member
my follow-up-
Berensky and then Member Moss.
My follow-up question, if I may, is just so stats on ballots. When does that become public?
When we release them, essentially, there's no stipulation that we have to report specific sorts of numbers at certain times, and that's why. But we do. I mean, every day we provide information regarding the ballot processing, and so we do give numbers regarding the vote by mail ballots because it's more of a concise process than provisional ballots that they undertake. But when we get to a certain point with the provisionals, once we go through the review process and we know what we have, then we start providing the actual numbers. And since the provisional process is a process, we don't look at the envelope, with the information envelope one time when we're done. We actually sometimes look at the same envelope 5 times, and we're trying to find. And when we review an envelope multiple times, we're trying to find a reason to count that ballot. So we're not issuing reports saying that we've got so many challenged provisional ballots because we're not done. So we don't put out numbers that aren't final with provisionals until we've actually made our final disposition.
And I noticed that in your letter you said that 6 days after the election, but 11 days before we certified the numbers, we started to respond to Ms. Morales. So it's that. I'm trying to get my head around that process and when you stamp those results, because in my mind maybe that and only then is something a public record. I could be wrong, but that was the nature of my question. Thank you,
Mr. Member Baranetsky.
I withdraw my question.
Okay, Member Moss.
It's getting late.
I just wanted to check. So when you say that they're not public records, I mean are they not public records, or are they public records that are exempted from release under the Public Records Act?
No, ballots are not public records. That was the question.
Right. So I think the better question is under what law or code does it state that ballots are not public records?
There's no explicit statement in the state elections code that says ballots are not public records, but it says that ballots are confidential. And the vote must remain confidential at all times, and so
then it's exempt information.
I guess. I mean, I don't.
Okay.
I don't view it that way.
Okay.
I find it hard to believe, though, that the number of votes itself is not a public record.
No,
the statistics or the count, perhaps the ballot themselves and who made the ballot, but the actual result of the ballot not being a public record seems bizarre to me.
No, that's not the question. So the question is, are ballots public records? Ballots themselves are not public records.
So the second question I did ask through the chair was,
statistics, right?
when do the stats become public? So that's our question.
Right. So as far as a raw count, we started that on election night and proceeded going forward based on our processing. And then once we got through the processing of the provisionals, then we had final dispositions. Then we released those numbers.
Okay.
So what's the timeline?
Well, the timeline, in this instance, the timeline was 1 week after Election Day. We were asked the number of provisional ballots that were scanned.
So,
and then the next day, I think Mr. Slocum stated an email that he didn't know that number. So that he indicated to me that was his answer. So that the day after that, I went and I got that number. We compiled some reports, and I got the number. So that was a week after Election Day.
Okay. So I guess just to finish my question, Chair Wolf, it seems like there's different stages of where these numbers become hardened, if you like. Mm-hmm. I would posit that at every stage, those are public numbers. However, I think you have to balance this whole thing with the rule of reason that you guys are in the middle of an election counting this stuff. And so how do you reasonably respond to requests while you're in this process? That's kind of where I'm seeing this going, but
okay.
Thank you.
Member Kanana?
Yes, I'm just trying to establish the timeline, and in the documentation we have, I see a request dated the 13th of June. And Ms. Morales, maybe you can answer this, because I see this dated the 13th of June. This is on page 404 in the document at 8:42 a.m., which seems to be the first request was saying to Mr. Slocum, I would like a request for the number of provisional ballots received on election night and how many were scanned during the first pass. When is the 13th the first time that was made, or when did you initially make the request?
Well, I had been observing at City Hall, so I actually had talked to Mr. Slocum about the posted ballot statements. So again, let me go over one more time. At the end of the night, at a poll place, there's this document that.
What was the date?
What night?
Okay, but
which night? The date?
The date of
June 6th, which is when the election.
June 7th.
Okay.
June 7th.
So on June 7th, these documents are produced at each polling place. People working the poll station. Okay, I'm going to tell you, there's a box that contains vote by mail ballots and provisional ballots in envelopes.
Right.
So the ballot, if it is private, of course, is inside the ballot, is an envelope. I don't actually know what's. So we count those envelopes, and you put the number that is in that box on this posted ballot statement.
Right. So did you make the request for this information on the 7th?
Well, I'm talking about the verbal exchange that I had before I sent him the email about these posted ballot statements.
Right. But I'm still confused on. So you had a discussion with Mr. Slocum on the 7th. Did you ask him for this information on the 7th, or did you wait until the 13th when you sent the email to specifically ask for the information?
I'm sorry, can you repeat that?
Let me just clarify. We're trying to identify, or Member Kanaz is trying to identify, when you initially made your request.
I inquired if those documents were.
We're talking about an official request, like when you made your request.
My official request is the email.
Okay, so on the 13th, you sent the email at 8:42 a.m. and then at the same day at 12:08 p.m. you sent the second one asking for the additional information.
Right.
Okay, and then that evening at 5:37 p.m. Mr. Slocum sent you an email.
Right.
Saying that they were still processing the provisionals, but he also sent you a link to a website that had information that was in a press release.
Okay,
my question is that information in that press release, did that give you the information you were looking for?
Well, it's debatable because in the department's updates 1 through 6, we submitted update 1. Their estimate was 20,000, but when I submitted the questions to Gregory Slocum, he never said the answer to your question is 20,000. So, and then when I asked about the scanned ballots, how many provisional ballots they had scanned, which is just the envelope part, he pointed me to the update 7 where they state that after they counted the ballots that they had determined that it wasn't 20,000, that it was 18,000. So I don't know if they've answered my question, how many they received on election night, because if they're not even counting what's submitted by the poll workers and adding those up, like if something happens in transit from the polling place to the warehouse or whatever, they don't even know. If they're waiting to just count them, take them out of the bag, and never actually reconcile to the report, which is what I'm asking. I want to know how many were received on election night, and that's why I would like to look at the documents, which are public because you post them outside the polling place, and then the copies, they're more in the original, the top parts go to the warehouse. So it seems like that should be a very public document.
Okay, thank you. And I have a question for the respondent then.
Mr. Arns?
Mr. Ernst. So on the 13th, now we're 6 days outside of the election. The first request for the number of provisional ballots received, was that known?
Well, yeah, we provide that information the next day. That's what I'm saying. So, on a daily basis, also, we're giving reports on the number of ballots that were processed.
Right.
I mean, so we're providing information.
But did you provide that information to Ms. Morales?
Yes.
Okay.
Okay.
Vice Chair Hyland.
Ms. Morales, if you could approach. Have you received all the documents you've asked for?
I haven't received any documents.
Okay, so you got some information from them, but the original parts of your request, those ballot sheets as you referred, you still haven't received those?
No, I was.
Okay, thank you.
No,
Mr. Arndt,
I haven't received them.
if you could approach. Is that something now that could be provided?
It's on our website.
So it's public?
Yeah, it's been on our website for several months, and I'm sure this was mentioned previously. This is my first impression of hearing that the request centered on posted ballot statements. And from the information I saw in the complaint package, this was a late addition to the complaint, not from Ms. Morales, but from Mr. Simpich. So at that time, I don't recall any conversation occurring. I don't remember seeing any emails regarding posted ballot statements.
Okay. And when were those posted on the website?
Posted ballot statements?
Yeah.
Never. So those are triplicate forms that are attached to the back cover of the voter rosters at each polling place.
Okay.
So one copy is supposed to be posted at the polling place, and then we receive the next two. And then we don't post those. We use those during the canvass. If we see an issue at a precinct and doing the reconciliation of the ballots throughout to the polling places and compared to what came back to us, then we'll consult the posted ballot statement.
So it sounds like you have a process in place to kind of check some balances.
Correct.
Along the way.
So those are records.
Hold on.
Oh, sorry.
That's good. I'm
Hold
done.
on.
Thank you.
I just want to say there's a whole process in almost everybody's campaign to send out runners to go look at every single precinct and those tags that are posted outside, usually with masking tape on the of the voting location. Right. So I have member Josh Wolf and then member Baranetsky.
So, Mr. Arns, I've lost what we call them, but the things that we keep referring to that are posted outside the door, and in this case, they were referred to as precinct ballot reports. Are those public records?
Yeah, those would be.
Right, they're posted outside.
Right.
So when the only thing that's able to look like a clear records request and response is this email from the 15th that Mr. Slocum responded to on the 16th. So on the,
What page are you on?
I'm on page 405. On this request, which is sort of tangential to the actual complaint, but I don't know how to separate them. The complainant is actually asking for the number of provisionals, number of provisional ballots received on election night according to precinct ballot reports. As of the 16th, would that information still not have been tabulated or collected?
Well, first of all, we didn't realize she was asking for posted ballot statements. We didn't know. That didn't ring a bell with us. She worked as a poll worker, so perhaps we thought she would know the nomenclature better. I don't know, but we didn't realize she was asking for posted ballot statements. That's why I'm saying tonight's this is really the first occasion that I'm hearing that posted ballot statements was the intended request, because I didn't realize it that way.
Let me interject for a second. The original request was not on the 15th; it was on the 13th.
I know the original request is on the 13th.
Okay.
But the original request doesn't explicitly talk about the actual sources of the records as a document.
I understand that, but then the conflation, it becomes conflated, because then we're dealing with which complaint is the real complaint. I mean, which request is the real request.
I mean, aren't they all real requests, though?
Yeah, but the point is which request is the complaint about? Because the original request didn't ask for those things. It just asked for a number. And then a few minutes later, there was a update asking for a list of items. And then it was 2 days later that another request was made. So we have to be clear from the complainant. Complainant has testified that this item, this complaint, is based on the request of June 13th.
Except that can't this be perceived as a follow-up communication of that original request?
But the question is if you made 20 requests all in an hour, then and one of them was not responsive, you're gonna that's what the complaint is about. So I think we need to clarify which request is the complaint against, because I see here maybe 3 requests, and now by you bringing up the 15th inquiry. The question is that within the same vein of information as what the previous requests are, or was that a brand new request?
Do we need to ask the complainant that question?
We would need to ask the complainant that.
Okay. Thank you, Mr. Arntz. Can the complainant step forward?
I just want you to, just so that everybody's clear, because...
Sure. So you have, I guess, 3 inquiries, at least maybe 4, where you were requesting information from the Department of Elections. Okay. How do you perceive the relationship between each of them?
I don't know how to answer that question. I'm really just interested in knowing how many provisional ballots were received on election night. Since the department originally had a figure that was 20,000 and then they changed it to 18,000, I just want to go back to that only way that we can perhaps really know how many they received are these documents. So I'm sorry, you can ask me again what the...
Let me ask you a different way. So when you sent this email on the 15th, that was, "Hi Gregory, your earliest convenience, I would like to request the following," and then you have 5 questions. Do you remember this email?
Sure.
Would you say that this email was part of your original request or a separate request for different information than what you had started off by requesting?
I mean, they're all about provisional ballots.
Were you just clarifying, maybe is another way to ask it, were you just clarifying what the initial request was about?
We run a stack here.
Okay.
So if you don't mind, let him finish his point, and then I could call on you. I got you.
So
let him finish, then...
I'm trying not to give you a loaded answer, and I'm not sure the clarifying is another way to look at it. But in essence, I'm trying to figure out whether the email on the 15th is part of the same request of information that you started with on the 13th, or is that something different?
I don't have the second email memorized, but I reiterate that I would still like the first question answered somehow.
Okay.
Which it wasn't really. I mean, they never really answered that question. I know they keep saying that there were these updates that they provide to the updates 1 through 7, et cetera, but they never said the answer to your question is this. And so, since they never answered the question, I keep asking it.
Right.
Okay.
Great. Thanks. Does that clarify your concerns?
No.
I don't know. Someone else.
I've got my own questions for this. Member Baranetsky.
I think a way to ask this is that what you're asking for in these separate moments, do you understand those to be part of the same? Are you interested in the same thing when you're talking, when you've been speaking in these separate instances? I don't know if that makes sense.
I don't understand the question.
Okay, so Mr. Wolf just mentioned there were these separate instances in the emails.
I mean, they're also in the provisional ballot category. How many you received and how many you scanned are like the first questions, because those are the department's own process. And so I'm asking them, but I understand that some of the questions were not answerable when I asked them, but I want to just go back to the first question, which really is, how many were received on election night? They kind of point to the update that it's 20,000. Is that the answer? That's why. The other thing is, I did ask Gregory Slocum if, because these seem like they should be public documents, if I could go to the warehouse, because the whole canvassing and the elections process is open to the public. So I asked if these documents, if I could just go look at them, because they're just bringing in all the materials. And it's supposed to be open to the public. And he said that these documents, the posted ballot statements, were only available to the public if the results were contested. So
here's basically the issue. Is the question is what the request that we're talking about here right now and that will be decided on, what it refers to.
Okay.
So there are several things that you asked for at different moments in time.
Right.
And the question is whether those should be all seen together as one package or whether those were separate little pockets that you asked for. And so the question is, are we discussing all of those together? Or are we discussing them separately? And to a certain extent, it depends on what your view of what your request was trying to aim at. And so we're all curious to know from your opinion, when you made these separate communications,
right,
whether you're just making separate requests or whether you were building on one initial request and sort of teasing out more what you were trying to get at. Does that make sense?
I suppose they are separate requests because the answer to the first request is separate from the other requests, but since the first question is never really, I never provided a satisfactory answer, I do keep reiterating the first one. So I'm really interested in the first request, which I still feel has not been answered, which is how many were received on election night.
Okay. Before we move on, so we're coming up to about 45 minutes on this item. We obviously need a little more time. How much time do we want to give this? 10 minutes? So let's give it 15 minutes, and then we're gonna move the process forward. Okay? Vice Chair Hyland.
Through the chair, quick question for Mr. Arntz. I just want to establish a timeline, and then I was going to maybe help try and summarize this for everybody. So the election was June 7th. The initial request came in June 13th. By June 24th, all the information that was pertinent to all of her requests was on your website by June 24th.
Except for posted ballot statements, because we didn't realize that was the requests for that information.
Okay, and did that subsequently become available on the website?
No.
Okay, is that something you release? Or have you released that to her?
No, this is the first instant that I'm realizing
tonight.
Right.
Okay. Is that something you can release to her?
We can. It's archived. We have to unpack and everything. But yeah, we can make copies of the ballot.
Okay.
Yeah.
Okay, great. Thank you. So just, and I could be off on this, but there's a couple of things that happened here that I do like. There was constant communication by Mr. Slocum with the complainant. I think there was some, obviously it was the nature of the request was difficult to ascertain. We're still finding out tonight what it really is, parts of it. A lot of the information was available on a public website 11 days after the first request, 13th, 24th. This was a normal information request, not an IDR from what I'm seeing, which would be 10 days. So there's a lot of things being satisfied here. We hear a lot of cases where there's no response, not timely, whatever. I think in this case, given that they're in the middle of counting an election, I think the Department of Elections did a good job of trying to respond to this request. I'm not seeing any violations here based on the overall flavor of that summary. I might be wrong in that, but so I would be inclined not to find a violation. That's just my position.
Yeah, Member Moss.
So jumping back to this question of June 13th versus June 16th or June 15th, I just wanted to point out a couple of things. First of all, the complaint itself references June 13th, and I don't know if it would be right to inform the respondent that June 13th is what the complaint's about, and then to ask them to defend things that happened on June 16th. When I do look at the June, I guess it's a June 15th request actually. When I look at the June 15th, the second one does seem to be a duplication of the first request, and so, and to that extent, we might be able to think of this June 15th request as a continuance of the same flavor of request. But items 1, 3, 4, and 5 are very different in nature. Some of them ask for an explanation of things. One is asking for an image of an envelope. One is asking for a reason why a web page isn't HTTPS compliant, which that wouldn't necessarily be a CPRA kind of request you could make. So I just wanted to raise that. I do think that number 2 is the same question that was raised the first time. But I don't think that, at least as far as 1, 3, 4, and 5, we should be considering that without another complaint being filed. That's all I have to say.
Okay. Member Kanan.
I just have one more question for Ms. Morales. You're saying that the answer to your first request, they gave you 2 answers. One was 20,000, and then they amended it to 18,000.
No, they never answered the question.
But
that was a hypothetical, I believe.
So where did those numbers come from? The 20,000 and the 18,000?
I mean, these updates exist, but I was never told 20,000 is the answer to your question.
But in these updates, is the 20,000 a number next to provisional ballots received on election night? I
don't know if that's the answer to the question.
So it's 20,000 of what? When you say in the update it says 20,000, 20,000 what?
Actual provisionals. Your question was how many provisional
were received?
So she got one answer, 20,000. She got
no.
another.
I did not.
You didn't get an answer.
I never got that as the answer to my question.
So that information though was public information that you got from their website?
Did you get it at all?
The updates are on the website.
Right.
They say that they estimated this number for election night.
Right. And then they amended it.
But is that the answer to my question? Is their estimate
So
how many were received on election night?
My question to you would be, I've got a bunch of questions, but the one question with response to Member Kanata is, was the response from your original request, which is what we're here talking about, right?
Right.
Was the response that you got some hours later from Mr. Slocum, was that responsive to your question?
No.
Okay.
I never got a response about how many were received on election night.
Okay, thank you. I think Member Eldon, did you have a question?
That was basically what I was going to ask as well. I was trying to understand. It sounds like the key point of your complaint is that you were seeing discrepancies in the number of ballots or provisional ballots they are counting.
Well, I couldn't see them.
Well, they were posted on you were looking at I'm just trying to paraphrase all of this because we're getting caught in a lot of weeds, and I'm just trying to make sure we understand what's really at issue here. You were looking at the website. You saw a number appear, an estimated 20,000 provisional ballots received, and then you looked again and you saw the number was changed to.
Well, so their update. Their first initial update, like starting June 8th, the day after the election, was that they had estimated 20,000 provisional ballots were received on election night. And my emails, I sent the emails on June 13th about this question, and then on the 15th I sent the one with this, how many were scanned. And that's when they start answering them on they changed the number on the update on the 7th. So.
Wait, are you saying that once you sent the emails, you believe they changed the numbers on their website?
No. I'm just saying I don't know if they even knew the answer to that question.
But I mean, the main issue you're trying to get at is to understand why they said one estimated number and then generated a different estimated number later, and why was there a difference between the two? That's what you're getting at, right?
I'm getting at,
I mean, that's
do they even know how many provisional ballots were received on election night?
And I mean, there are all sorts of implications because there's all sorts of history in the city about.
I know that, but we don't. We're not. The elections code is not in our jurisdiction.
Right. I'm just trying to boil down. Sort of, what the complaint was intending to receive and whether or not she is receiving that information.
Can I address that?
No, not yet.
Specifically because I'm having trouble following some of the details here.
Yeah. Member Josh Wolf.
Okay, so I think we can clear away some of the weeds with this question. So some people, when they come to the Sunshine Task Force, are looking to change the historical behavior of a department. So they want to add up those violations to get them to follow the law. Sometimes they want they want it referred to ethics for whatever reason they want it referred to ethics. And sometimes they just want the information. Which of those three, or maybe there's a fourth, are you looking to leave tonight with? Are you just still looking for this information? Or are you looking for a violation? Or what are you hoping to achieve tonight?
I would like the public to be able to see the posted ballot statements or things that are supposed to be public.
And so if the Department of Elections is able to provide you with those posted ballot statements, would you have all the stuff that you're looking for at this point in time?
Sure.
Great. I don't have any other questions.
Okay, my turn. So I'm going on Ms. Morales. I'm going on the original request that you had made on June 13th at 8:42 a.m. It says to Gregory,
right?
Who I imagine is Gregory Slocum, because there's another email on June 11th from him to you that is included. It says, I would like to request the number of provisional ballots received on election night and how many were scanned during the first pass.
Right.
Okay? So this is not an immediate disclosure request. So you're not asking for that information within 24 hours. This would be considered a standard sunshine request, which gives them about 2 weeks to turnaround time to give you this information. So then Subsequent to that, at a few hours later, at 12:08 p.m., just after noon, you asked for some additional information.
Right.
That seems somewhat kind of being a little more specific about your first question.
Okay.
So I'm going to consider both of those your request. Okay? So you said you would also like to request the numbers for provisionals that were challenged, not found, accepted, so on and so forth. Those are basically details that would be within the total number, correct?
Yeah.
So you wanted the number of provisional ballots, then you wanted a breakdown of those provisional ballots.
Right.
Right? Okay, so I'm going to consider both of those as your request. That's what this body is going to, I'm going to request that this body declare that as being the request. The June 15th request to me seemed somewhat tertiary, seemed somewhat different than this core request. And everybody's been asking about the request, you keep coming back to this. So I'm just going to say I think we're in agreement here that you're asking for the provisional ballots and you're asking for the breakdown.
Can I say something?
Yeah.
So perhaps I'm wrong, but I hope that I didn't have to, when I make a request for certain information, that I don't have to say the magic words to get that information.
What magic words?
The posted ballot statements. I didn't make that request. I didn't specify that in my June.
It doesn't really matter to us because the actual detail is really not as important as the process.
Okay.
You made a request. Did somebody respond to it? Was the information responsive to your question, to your inquiry? Right. If it was or wasn't, how much of it was, how much was it wasn't? Was it all responsive? Was none of it responsive? So we've had cases where somebody would ask a question about one thing from one person, and the whole department delivers 400 pages that have nothing to do with that person's question.
Right.
They asked about a little email, and they got the whole program. Okay? Mm-hmm. It's unresponsive. They didn't get what they specifically asked for. Right. They didn't ask for the department, their response. They asked this one person for this one thing. Right. Okay? So that's not in relation to this case. That's just something else. But I want to be clear. So on June 13th at 5:35 p.m., Gregory Slocum responds to you. He says, "We are still processing the provisionals.
Right.
As such, we do not have figures yet that you have requested. We will likely have these figures later in the week as we finish processing, and they will be released then. The department has just issued the press release and so on with the link." Okay? So now I'm asking, this is his response. It's perfectly within the time frame. It's in the same day, okay, which is very responsive in my view. But was his response the information that you requested?
There was no response to how many ballots were received on election night.
Okay, so I'm going to stop you there for a second. I'm going to ask Mr. Simpich to come up, because he made a statement, he made some testimony earlier with regards to the election code.
Right.
Okay? Now, we have no jurisdiction over the election code, but the question is, if the information was to be available within a certain time frame, then I'll have another question for Mr. Arntz. Okay? So my question to you is you stated in the election code that let me ask you the question. Were these numbers supposed to be provided within a period of time that would have been reasonable for Ms. Morales to receive them?
Yes, those records should have been given within 24 hours or less after the polls were closed.
Okay, and that is a requirement under a law?
That's my reading of the law, that they've got to do it basically that night, get those documents to the polls and hang the document out on the poll so anybody can go to their polling place and see what the count was.
Okay, so we'll stop there. Mr. Arntz, don't go away. Don't go away. Just stay there. Okay, so let's. I just want to get some corroboration here. Is that a correct? Do you find that to be correct or not?
No, there's nothing in the Elections Code that requires a 24-hour turnaround for copying posted ballot statements and providing them to an information request.
Okay. All right. Thank you. Okay. So, Ms. Morales. So, in this period. So, first of all, I wanted. We'll get to rebuttals at some point here and pretty quickly. But all we're really concerned about here is whether the department was responsive to your request. First of all, in a time factor, which I think they were. They responded pretty much the same day. Okay? They responded that they didn't have the figures that you wanted. If you have a concern that they were not following the elections code and not providing that information as per the elections code, that's something that we cannot adjudicate on. We cannot in our jurisdiction. It's not in our jurisdiction at that point. So only thing we could do is determine whether they were responsive and whether the information they provided you was responsive or not. Is that clear?
I mean, they responded, but it was a non-response.
Right. So they responded appropriately. If they didn't respond in 14 days, they just blew you off.
Right.
It's like maybe they answered you in a month later. That would clearly be a violation because they didn't respond within a certain period of time, which is 2 weeks. So, but they did. They responded the same day. Okay. The question is the information that they give you, was the information responsive to your inquiry?
I don't feel the inquiry about how many were received on election night has ever really been answered.
Okay.
And also, because we're talking about elections, this should be, if anybody has a question about this.
I clearly understand, but
Okay.
our jurisdiction is narrow when it comes to this. This is about asking for public records. Did you get did they answer to you in a proper time? And did they respond to your request? Did you get the information that you requested? And if you didn't get the information, it's up to them to prove that they were correct under the law not to provide you that information.
I feel like I have not received
You haven't received, okay.
a proper response.
Okay, so Mr. Arntz, the information she's asking for, she says that she didn't get the information that she requested, okay? Question to you is was that information available at the time? And I mean, because with regards to the parties that Mr. Simsich that iterated or interpreted the election code, the information should have been available at the time.
Yeah,
you're saying it's not.
From my perspective, things are getting mixed together. So the original request was for the number of provisional ballots received on election night.
Right.
That's the 20,000 number. That's the information that was provided in the press release. And that's where the link to the press release comes. So we made a public statement on the number of provisional ballots the department believed we received on election night. And we issued that the day after the election.
Okay.
So that preceded the request. Then there was another request that came in.
It preceded there. You mean it was available before she requested?
Correct.
It was available on June 12th?
No, June 8th.
Oh, it was
the day after the election. This was on our website. We issued a press release.
Okay.
Then the next question was the number of ballots that we scanned. And Gregory, that's Mr. Slocum's first response. I gave Gregory the number because I asked the folks who run the equipment to compile the information. We gave her the number. I couldn't find it in writing, but I have the information I sent to Gregory.
So she did, in her original request, she asked for how many were scanned during the first pass. And his response was not a number. It was a press release. It was actually, it says San Francisco Department of Elections ballot processing update. I guess, is that a press release?
Right, every day,
Yeah,
so
it's
we're
a press
giving
release.
accounts.
Right. This was number 7.
Pardon me?
So this says, it was a press release. It says the department just
update
issued a
number
press
7.
release.
Yeah.
Okay, and I guess it's update number 7.
Every day we issued a press release where how many ballots that we thought we had in hand, how many ballots we had processed, how many left to process.
Okay, and words, the number of provisional ballots contained in that press release?
Yes.
And was the breakdown of the provisionals provided in that press release?
No.
Okay. Thank you.
Mm-hmm.
Okay, any other questions? Okay, let's move to...
I have
yes.
one quick question.
Member Canado.
Was the breakdown that was asked for on the 13th at 12:08 p.m. ever provided?
It's on our website. It's on our website right now.
When was it on? When do you know when it was on your website?
The day she filed the complaint with this task force.
24th.
Okay, thank you.
24th. Okay, great. So let's go to rebuttals. Sorry.
One, out of order, I guess. But so reason that the breakdown was not in the press release is we weren't reporting. We didn't have that information. We were still processing the provisional ballots. So I didn't have a report to issue at that time.
Okay. Thank you. Yeah, respondent first. So, Mr. Arntz, you've got 3 minutes for any rebuttals at this point.
Oh, well, I mean, again, we try to be very responsive to all the information requests we receive in the department. This is no different. You can see Mr. Slocum responded very quickly. It wasn't just a matter of Mr. Slocum. Other people in the department had conversations with Morales for several weeks after the election on the points that were brought up. The numbers that we could provide, we did provide to her. The breakdown, we didn't have that in hand. We don't track. There's a lot of misunderstanding on Ms. Morales' part about our process. We tried to explain it through the time of her questions. We did not ignore her questions then about the process. We gave her tours of the department. We took her to the different divisions. We introduced her to the managers of the divisions. They went through their process with her. So we tried to be very responsive, not just in written emails that we received, but also to provide a sense of what the process is, what's happening, and we were very consistent throughout the election. I write press releases on a daily basis on the number of ballots that the department has in hand. It's the best of its ability to know what's on hand. We issue a press release. In the press release, the number of ballots that were processed. We break it down by provisional and vote by mail ballots, and we do that until we're done processing ballots as we go through the canvass. And then when we're done, when we know the disposition of the provisional ballots, we release it to the public. We put the information on the website. We've been doing this for a while. So. Yeah, and several of the issues have come up. I understand that perhaps the nomenclature of elections is not clear to everybody, but we didn't realize that the request was for posted ballot statements, which is a piece of paper that's attached to the back of the rock. We could have, if we thought that was a request, we could have had that done in a couple of days probably. There would have been some missing pages because now the rosters come back right away, but we could have got that. But we didn't understand that was the actual request. So, thank you.
Thank you. Ms. Morales, you have 3 minutes for any rebuttals.
This was not an attempt and is not an attempt to find a technical violation. This is an attempt to get the posted ballot statements that have the actual number, not an estimate. This is the reason that Ms. Morales is here. Ms. Morales has said repeatedly, I want to know the number of provisional ballots received on election night, and she offered clarifications after that. There's no mystery about the fact she wanted the posted ballot statement. I believe she mentioned it again on the 15th, and she also, through me, brought this to their attention last week, that we wanted the posted ballot statement. It's not really about anything else but the posted ballot statement. I don't know how many times I have to talk about the posted ballot statement to make that clear. There's been an attempt by Mr. Arntz and Mr. Slocum earlier to not address the question about election night. They keep talking about the number of provisional ballots. We don't know about the provisional ballots on election night. That's what the question is. The exhibits we gave a sample of the posted ballot statement, and they also say that the posted ballot statement fills out the number of provisional envelopes under G, and that gives you the actual number, and that these documents are to be posted. And I gave you the statutes on that, and I think we also gave you a copy of the poll worker manual that addresses that. So there's not a lot more to say other than that when she asked the question on the 13th, the response she kept getting was, we don't have the figures you're asking for. We'll give them to you later in the week. And if you want to take a look at the press release, it'll give you an estimate, which is what it did. She wants the real figures. They're in the posted ballot statement.
Members? Vice Chair Hyland.
Through the chair, we've heard Mr. Arntz say that now that he understands the question, he can get that information to them, and I'm persuaded to believe him. I still feel there's not been a violation, but if we decide there hasn't been a violation, I'd like to see some sort of follow-up that piece of information does make it to Ms. Morales, so perhaps a follow-up. I don't know how we follow up on something that we don't have a violation on, but if we can be creative about that and just get some confirmation that final piece of information makes its way to the complainant, then I would be satisfied.
Are you making a motion for a violation?
No. I'm saying I don't see a violation.
Oh, okay. Sorry. Misheard.
Member Josh Wolf.
I mean, I think that, in essence, what Vice Chair Hyland said probably makes the most sense. I think that basically the complainant and her attorney can follow up with the Department of Elections and hopefully receive this now that it's clear what they're looking for. And if for some reason they're not able to receive it, then they can file a new complaint and we'll address that at that point, because at this point, like, it appears, and I don't see any reason we shouldn't take Mr. Arntz at his word, that what they were looking for was not quite clear to him until this point. He explained that he could get that information from the archives and provide it for them. I have no reason to think that's not going to happen. I think we should just allow them to work it out, and if they're not able to, then we should request that they file a new complaint if it doesn't work out, and we should expedite that as much as possible.
Anyone else? So I hear that. My concern is that if there is another section of law that makes a requirement that's not in our jurisdiction, but it makes a requirement, and it makes that requirement with a certain time frame, and that information should be available within that time frame, and then somebody asks for that information, and then it's claimed that it's not available. That's going to be a concern for us, that the response wasn't responsive to the inquiry, that there would be some information that was being held back for some reason, because it should be available. If the law says that this particular type of information needs to be provided within a certain time frame, period of time, and should be available to the public at this particular period of time, then you ask for it, and it's beyond that period of time, and they're telling you that it's not available, then that becomes an issue for us. So I am, I'm still not. What's not clear to me is that I'm not convinced that the complainant has presented to me that they were looking for this particular item. All I read is the number of provisional votes counted and what the first pass is. Now, if this is very specific nomenclature, I would like to get some agreement that that we're talking about the same thing. That's apples and apples. Macintoshes and Macintoshes, not delicious and Macintoshes, or we're apples and oranges. I want to make sure we're talking about the same thing, because then it makes our job a whole lot easier. Otherwise, we're not doing anybody any justice here. Okay, so I want to inquire one last time about about the statement of, what was it called? The
Posted ballot statement.
Posted ballot statement. If that, so Ms. Morales, if you can, I'm gonna push the boundaries here a little bit. I mean, you said it before. Did I have to ask the magic word? Well, kind of, yes. I mean, is it obvious that, is it really obvious as a poll worker, is it obvious among talking to other people in the office that a count of the provisional ballots and a count of the scan of the first pass is this, somehow it escapes me again. What's the name of it again?
Posted ballot statement.
Yeah. Posted ballot statement. Is that, I mean, is it obvious to everybody in the office that that would be what you're talking about?
But I did ask if those were viewable to the public, and
but on your original request, because that's how you presented your case here to us.
Right.
Was based on the original request.
Right. So my request is this number from election night. Why don't you have this number?
No, I understand that, but if it's the little tag that gets hung on the front of every single building, and they get the other two of the triplicates, are you saying that they should have the number?
They should know this number.
That?
I mean, that's their job.
Okay, and is there a requirement for them to have that number? I mean,
I would hope so.
No, but within what period of time? I mean, is there a requirement for them to have that number in a certain period of time? If they're required to have that number, let's say 20 days from the date of election.
They should have a counting of that, because what if somebody walks off with a bag of ballots? If they never actually check it
right, but
within a time frame, then how are they going to know?
I understand that. But the thing is we're not the election commission. Okay, so we don't really have any idea of how all this works. All we can do is determine whether the information you requested you had gotten or not.
Well,
and so that
is still the question, isn't it?
Well, but that's the thing. If they were responsive by saying we're still counting them, and we don't quite have that number for you just yet, a few days after Election Day, and they don't have to certify the election until weeks later.
Right, but somebody has counted them.
How do you know that?
Because every poll station has a red box, and they counted them, and they put them in on the statement.
And then the question is the next place that that document goes to is the department itself, right?
One of the duplicates is posted publicly,
right?
And
the
rest goes to the department,
right?
And so it doesn't make sense for one to be public and the other ones not to.
Right. And so, what is the requirement for them to be counting the provisionals at that point? Though all those little pieces of paper for all the precincts.
They're envelopes.
Right. So
it's not that. It's not. I mean, it's not that many.
I understand that. The question is when is the appropriate time for that? Is there a very specific timeline for that to happen? That's really the question.
We count them election night.
You can't just say that because they're rules.
Yeah.
Okay. What are the rules?
They're counted so the precinct board shall immediately transmit unsealed to the elections official a copy of the result of the votes cast at the polling place. The copy shall be signed by the members of the precinct board and shall be open to public inspection.
Okay.
So they are counted. Just because they haven't recounted them
And you asked for the first pass. So this is the first pass? Is this what you're talking about?
That's a different question. My first question is how many were received on election night?
Okay.
And the answer to that question is the poll worker counted them at the polling place and filled out a report. So if they're not even paying attention to how many are received on election.
Okay, Mr. Arntz, let me ask you a question. I just want to make sure that all the members are getting all the right information, because if I'm not understanding it, I'm not sure if everybody else is. And it's no disparaging on anybody. I just want to make sure everybody gets this train of thought. On election night, when the poll workers send in, or it gets collected, these envelopes with the number of provisional ballots on these envelopes, when are they counted? Are they counted on the spot?
No. Well, you're mixing processes too. So on the back of the roster, which has all the names of the voters at the polling place, there's a triplicate form called the posted ballot statement.
Right.
On that posted ballot statement, there's a field for poll workers to write the number of provisional ballots that were cast at that polling place.
Right.
The sheriff's deputies pick up those rosters, and that goes into a different bag than the provisional ballots. But both bags come back to us at our warehouse. We're focused on the provisional envelopes. We're not counting the numbers on the posted ballot statements. We're hand counting and trying to organize to get the ballots to City Hall. So we're not actually dealing ourselves, our process.
So what was the law that she was reading from that described a very specific process for counting?
So if there's a tabulation that occurs at polling places, the poll workers are to account for the cards cast at that polling place.
But you don't count those cards?
So not the provisional ballots. So the cards, so if the whole process is there's tabulators at the polling places. So that the voter cards go through the tabulators. There's a memory device that's a part of the tabulator. The parking control officer grabs the memory device, brings it back to City Hall. That's how we upload the precinct results. We're not counting information from poll workers on election night or even going forward. We don't use the posted ballot statements until we get a problem we have a reconciliation issue at a polling place. Then we consult the posted ballot statement. But we don't compile the information on the posted ballot statements at all unless we have reason to. And we don't make copies of those unless it's requested. It's not a habit for us to get that request.
Okay, so thank you. So, Mr. Simpich, I'm not quite making. I don't want to make fruit salad here.
No.
Okay. I mean, are we talking apples and oranges, or are we talking about the same thing?
I don't think we're talking about the same thing. We're talking about the provisional ballot count is based on the posted ballot statement. It's our understanding that these are hung out on all the polling places within 24 hours after the election is over, which is June 7th in this case.
Mm-hmm. And you're expecting, and Ms. Morales was expecting there to be a tabulation of all those by the Department of Elections.
Well, that's right.
Is there a requirement? So are you saying is there a requirement for them to provide a tabulation?
That's our understanding is that they do tabulate from the posted ballot statement, and they post these right after the election. And Ms. Morales could come back up here. I could make an offer of proof saying she could tell you that she went out and collected a few of them, but most of them weren't there. And that's why she wanted to know what's the actual number.
Okay. Thank you.
Yeah.
So I'm sorry, members, to belabor it, but I'm just having a hard time in understanding who is right and who is right in this sense. I don't necessarily have enough information.
For me,
Member Canada.
For me, a lot of the confusion has been semantics. Provisional ballots at the polling places. What's the count of those? And then these posted ballot statements. And I keep hearing explanations of each one, and they don't jive. I would think that by the 13th of June, whatever press releases were out would have the number of provisional ballots cast. And if that information was given to Ms. Morales by saying, go to our website, the information is there, and then saying for the other information you asked for, we haven't had them tabulated yet. To me, that sounds like a good faith effort to provide
But that
information.
sounds like the response that Mr. Slocum gave
Right.
on the same day.
Right. And so
We're
that-
still processing the provisional, so we don't quite have the figures yet you've requested. We're likely to have these figures later in the week as we finish the processing. So I'm not quite
No, I'm saying I don't understand because the request on the 13th asked for the provisionals, and then they keep referring to the request on the 15th that asked for other things that seem to be the posted ballot statements. In none of these requests is that terminology used. So I mean, I don't know if it's apples to apples. I don't know if what we're trying to adjudicate is, that we have the information. The one party says the information was given, the other party says we didn't receive the information we asked for.
What's the pleasure of the members? How do you want to dispense with this?
Can I make a motion not to find the violation?
Do that.
There's a motion.
Member Joshua.
Is there any way?
First of all, I should ask, is there a second?
I'll second it.
Okay.
Is there any way to follow up with them other than having them file a new complaint if they're not able to solve what they're looking for?
Well, yes.
If you adopt this motion, we can send it to compliance amendments with a request for an update.
That sounds like a great approach to this
That was
to
my
me.
plan all along, yeah, just
Okay.
Would you like to amend your motion?
as amended.
I believe the motion is to find that there is no violation and to request the Department of Elections to, I believe, provide the posted ballot statements to the complainant. If I am, did I get that correct?
Yeah, it'd be the information she's asking for. So the information would be the posted ballot statements and the count, I'm sorry?
Of provisional ballot.
Of provisional ballots.
I have that. Thank you.
Is that correct?
Yes.
Okay, great. And that this will be referred to Compliance Amendments Committee?
Unless withdrawn by the review.
Sorry?
Unless withdrawn for compliance. Yes, refer to the Compliance Amendments Committee. But the idea being that if the complainant gets what they want, they can then, I'm just educating them.
Well, there's
that they
no violation, so
Yeah, right.
the idea is just as a follow-up. Mr. Arntz, is that okay with you?
Can I speak?
Yes.
Yeah, it's fine. With posted ballot statements, we can put those together. Again, those numbers aren't going to match the final number we have on our website because the numbers aren't always correctly written down by poll workers.
She was asking for the first pass. Okay, that was one part of her
Okay,
original
not a problem.
request.
But-
Okay, and then she was asking for the count of the provisionals at that time on that day.
Yeah, again, the number we thought we had in hand was publicly stated in a press release that's on our website.
Okay.
So that's not going to change.
Right.
As far as that point, I mean, afterwards, we did have, I think, 2,000 less than the estimate. That's on our website. It's all broken down.
Okay, well, if you can provide what the final total was, plus the first pass count that I think that she's asking for.
Sure.
Okay, appreciate that. Thank you. Okay, public comment. Any public comment on this? No, Ms. Simpich, you're party to the... Party. Okay, this is for general members that are not party. Okay, seeing none, move to a vote.
On that motion, Member Barnetsky.
Yay. Aye.
Barnetsky, aye.
Aye.
Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra, absent. Tesfa, excuse. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Fisher, excuse. Member Hensy.
Aye.
Hensy, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf. Aye. Wolf, aye. This matter will be referred to the Compliance and Amendments Committee for follow-up.
Thanks.
Next item, please.
Next on the agenda.
Thank you for your patience, everybody.
Item number 16, Administrators Report, Complaints and Communications. First on my report is the hearing schedule. The September 12, 2016 meeting of the Compliance and Amendments Committee is scheduled for next week on September the 12th. We have Member Kanata, Member Highland, and Member Moss scheduled to attend. I was wondering if there are any problems with that. Next, I do have an error in my report for the next Complaint Committee meeting. It should be September 27, 2016 at 4 p.m. I will be working with Chair Tesfa to finalize that agenda shortly. And I do need to confirm membership for that meeting, as I believe that Member Barneski is not sure if she can attend that meeting at this time. And I have not yet confirmed with Member Hensey.
I'll be on vacation, so I can't.
So we do need at least one member, if there are any volunteers.
It's for
September 27th for complaints.
Complaints. Anybody can fill in?
I can check and get back to Victor about that.
Great, appreciate that. Thank you.
I will put out a poll once I get confirmation from the other two members. Next meeting, Sunshine Ordinance, October 5th, and then the Education Outreach and Training Committee will be October the 18th. I believe that we have a little bit of trouble with membership on that day, in that I believe Member Wolf is not able to attend on that day, or
Yeah, so one of us, either Vice Chair Highland or I will.
And I believe that it is a holiday. I believe that Member Fisher may have a problem with that day also.
The Yom Kippur? Is it Yom Kippur?
Sukkot.
The Rosh Hashanah?
No, Sukkot or something to that.
Oh, okay.
What date is this again?
Rosh Hashanah is in
I
September.
believe it is a Tuesday.
I should be able to, but I need.
I'll send out a poll since this is so far away. I will poll the members for possible replacements.
I should be able to.
This is October 18th. It's
Oh,
a
yeah.
month away.
It's a second day of Sukkot. Okay.
In which committee?
I'm on that committee and I'm good for it.
Oh, yes. I did have you
Just so
listed
you
there.
That was EOT, right?
Yes. Next, I have a list of the submitted complaints along with any withdrawals that have already occurred. Next on my list is the pending complaints. We are holding steady at 33 at this time. And then I have a list of pending issue before the task force and committees.
Great. Thank you. Any public comment on the administrator's report?
There's no public.
Oh, no public here. Okay, great.
We've
Thank you.
outlasted them.
All right. So next item. We're almost done. Call the next
And
item.
then I do need to, as we spoke about, we do need to eventually set a rules committee meeting to consider the complaint procedures.
Right.
I will work with Chair Hensey on that.
Right. I'll attend that meeting also, just to kind of help out.
Next on the agenda is item 17. Announcements, comments, questions, and future
I'll take
agenda
it.
items by members of the Sunshine Ordinance Task Force.
Okay. Yes, Member Moss.
So I have two. Should I take them one at a time?
Yeah, go ahead.
So first, I just wanted, it's kind of informational. There is a bill sitting on the governor's desk right now that is of relevance to us. It's AB 2853, which would allow government agencies to respond to a public records request with a link to the government's website where they can download the files. If the requester is unable to download the files because of, say, a disability or because they don't have a computer, they would then have to write back to the government agency and say they're unable to do so, and then the person would process it as normal. I have some concerns about this piece of legislation, which I'm dealing with in my professional capacity outside of this task force, but I did want to raise it, make the rest of the task force aware of this piece of legislation. So that's the first item. So I don't know if we have to do anything after that before moving on to the second one.
Well, I just have a comment about that. Considering we have our own Sunshine Ordinance, we may be able to kind of take a position on that, and I'll inquire.
Okay.
And if we want to take a position, well, it's kind of hard. It's late in the day to do anything. So
yeah. He may act on it.
He may act. Okay, but if we wanted to maybe interest the city in maybe taking up our position and doing something with, we can have a discussion on that in the future. Thank you.
Okay. And then the second one? So I brought this up at the last two meetings. I just would love to talk about SB 272, the actual state law requirement about data catalog or enterprise system inventories that need to be posted online. If that needs to come up in compliance and amendments, we can talk about it in compliance and amendments. If it should come up here, I would love to get someone from the City of San Francisco's open data portal to come discuss it, because I do have some concerns on how it is being the amount of compliance they have with the new section of the Public Records Act. That's what I got.
I would just add for that the supervisor of records should also be involved, because that's the person who manages the index of records, so which is part of that inventory, or kind of describe. Maybe it needs to be increased, or whatever. Okay.
So should that be here, or should we do that in a committee?
It should be done in committee. So why don't we have? Yes, we're running a little over.
About 5 minutes out.
What committee should we have this compliant? Maybe compliance and amendments?
That is one that I sit on, so I would appreciate that indeed.
So why don't you keep both these items? I'll refer it to CNA, both AB 2853 and SB 272. You keep a watch on it. If you think that we need to take a position, or there's some concern that the city should take a position on certain things, report will be good. You can, get it to me, and Victor directly. We'll see about getting something like that processed. But you should, if you think that we should take some action on it, please do take action on it so that the task force can at its very next meeting. Okay. Thank you.
Thanks.
All right, any other announcements? I just want to welcome Ms. Baranetsky to our fold here. I know it's maybe daunting, maybe not, maybe frustrating. But I do want to say that sometime in the future, I'd like to take some time out in a meeting somewhere just to provide a little bit of orientation, because we had some issues with process, and many of us are new. So we're not quite sure what the process is or what, and we are having to reinvent some wheels. So I want to do that sometime in the future. The other thing is I want to ask Victor, if when you're calling the roll, if we can mix it up a little bit. So seat one isn't always the first one, because I'm sure on the first day that was like, uh-oh. But I'm wondering if we could make...
You can do it by month.
Well, like I mean, like I would say for every item, like, the first item could be seat one, the next item...
Copying the Board of Supervisors, they usually change it by meeting, the order, if you want to go with that process. Changing a vote for every vote count...
Well, it's just changing the order, that's all.
So that's tricky. Like, I'm anticipating when my name is called, and I realize you're going to always be at the end, but if you're not the chair, then it becomes really problematic.
The dealer's choice for Victor.
Well, if I'm not here, then somebody else will be the chair. They will be the last one.
No, I mean, like, if you stay on the Sunshine Task Force,
I see.
and I stay on the Sunshine Task Force,
Yeah.
we adopt this system, and then someone else becomes chair.
Oh, I see.
Then they're like, member Wolf, which one? Member Wolf, which one?
Oh,
we have
that's
first
why
names.
I state your first name when I call your name.
This is not the hardest problem we've tackled here.
I just wanted,
I will consider a method, and I will implement it at the next meeting.
Great. I'm just saying, you could do it for every item.
However, chair always votes last.
Yeah, chair always votes last. Break a tie.
I've been third for like 3 years.
Is that what you mean by really problematic?
You want to have a lottery? Who gets what?
You'll be first next week.
Okay. All right.
So they'll just roll it out.
Anything else for the good of the cause? Seeing none, is there a motion to adjourn?
Public comment?
Public comment. Yes. Sorry. On announcements. Thank you.
Peter Warfield, Executive Director of Library Users Association. First of all, I want to thank the task force for taking the time that it has to consider things. Obviously, I'm not entirely happy with everything that has happened. With respect to Member Moss's concerns, they sound very interesting. I'd certainly be glad to hear a lot more about it if there were any material to read. I would note that Section 67.30 gives you very broad powers to make comments and advise. So Section C says the task force shall advise the Board of Supervisors and provide information to other city departments on appropriate ways in which to implement this chapter, and it goes on, and at the end it says, the task force shall from time to time as it sees fit issue public reports evaluating compliance with this ordinance and related California laws by the city or any department, office, or official thereof. So I think that section, and there's some other stuff in there, but basically I think you have very broad powers, and I don't see any reason why you shouldn't invoke those in what you're doing. With respect to the order of votes being taken, I've always said with the name of Warfield that when I'm king, everybody will be called in reverse alphabetical order. I did go to junior high school with 4 Peters, and we had that problem or that fun. And Billy Zukov was one of the folks in my class, so he would certainly be ahead of me in a reverse alphabetical order. The chair mentioned process issues. I certainly think you have quite a bit of process issues here. And I wanted to say that I attempted yesterday to follow up on a conversation that I had with the administrator about what the process is for referrals from a subcommittee, which is not documented anywhere in your bylaws other than to say what my experience was, which is complaint committee makes recommendations to the full task force, but the complaint procedure is very clear. You have a full hearing following whatever recommendations, including particularly the question of jurisdiction. So I ended up making a second request to the administrator today and got an answer to 8 questions that I had specifically about the referral process. And question 7, and this is before before the hearing that I had, voting, and I put 4 stars on that one, and one other question, here's my question, must the minimum of 6 votes be cast to endorse and follow the committee and so on? The answer was a quorum of the task force, 6 votes, is required to adopt the recommendation of the committee. And I don't see that happened today. And I'd also like to ask the chair, I didn't understand what the conclusion was. I think it was to throw out the case and drop it. But I also didn't understand something said about refiling, which kind of shocked me because there was so much huffing and puffing about duplicative. So I'm not sure I understood what happened. I think you tossed out my case with no hearing, and I'm not sure what you said about refiling.
Okay. I thought I had answered that during the meeting. We were going through what the current complaint process was. And that's...
So can you tell me what my options, if any, are? Did I understand correctly that 15-162 is finished?
I would think so at this point.
And I heard the refiling word, and I didn't understand that.
I don't remember refiling.
Okay. In any case, I don't think that there happened what I was told by the administrator is what's supposed to happen, which is 6 votes is required to adopt the recommendation of the committee.
I'm not following you.
I believe there's a little misinterpretation. I believe my intention was to state that there is 6 votes needed to approve a motion of the committee. And in the context that the question was provided, that was my intention. But my intention was to state that 6 ayes or a quorum of the task force is needed to adopt a motion of the task force.
It's to approve any motion on the floor.
Right, but we never approved any motion. It just died in committee.
No, you made I
made a motion that didn't pass, and then we didn't make a subsequent motion. We just based the fact that my motion didn't pass as the nexus, the delta, did pass, but
the delta was no motion. Thereby it passed.
No, but it doesn't, because you need 6 votes and there were only 5 to pass. So actually, it doesn't.
The thing was the committee didn't find a violation.
Right.
So there was no vote to be taken. The recommendation was to find no violation.
Right, but okay.
All right. So your motion was not to accept the committee's recommendation, right? Which then everything goes to a hearing then. And then because your motion did not pass, then it stood. The recommendation was to find no violation. So essentially, I would have asked: is there a motion to support the complainant? It's as if nobody made a motion.
Right, that's exactly what I'm saying. But when Victor used the language he used, he actually worded it slightly different. It might not be written down in the record that way,
but it's 6 votes to pass any motion on the floor.
Right.
That's it.
Yes. No argument there.
Okay.
No motion passed regarding Mr.
Can we do the
Wood.
microphone,
right.
please?
Yes.
Mike?
Maybe we can take this
Sorry.
after. We can discuss this after. Good case study, though.
Okay. That's all right. So what was you want to? Was there something else you want to say?
No, as I said, I think it's urgently important for these new procedures, which many times seem to go by the seat of the pants, to be documented. I think you've got a rules committee that can do that.
Right.
And I think Member Wolf is right. There was no motion that passed.
Right.
And so, therefore, it's not clear to me that the motion was adopted to agree to what the subcommittee said.
But here's the thing, Mr. Warfield. If the hearing did come to the task force, we went through the whole hearing process, and then I asked for a motion, and everybody was silent, it's the same result.
Well, as I said, I'd be glad to forward this to you, or maybe Victor could. It says a quorum of the task force is required to adopt the recommendation of the committee.
If there's a recommendation.
The recommendation was no violation. So I don't hear that there was a vote for no violation.
There was
And
a
so
vote
I
not
understood.
to. I understand, but there was no motion at all. There's no motion. The only motion was not to accept it, and and that failed. Okay, so essentially, it was essentially the same result happens. Are you asking there should have been a follow-up motion to find? That would be duplicative. That would be not.
Well, if the vote had gone forward in the way that it was stated in the agenda, I believe you would have had a 5-4 vote. You would not have passed the motion that was in the agenda.
Well,
in which case, then what?
But that's speculation. How do you know there would be a 5-4 vote? It was a 6.
Because four people supported not following the recommendation. 4 people said we shouldn't find that there was no violation.
All right, I don't
Right,
know
so
what to
in
say.
essence, it died on the vine as opposed to being formally adopted to not find a violation. But the outcome's the same either way.
If
Sorry.
you can't get a majority to take an action, then no action has been taken, and that's one of the questions. What happens?
And that's my point, is if no motion comes to the floor, then it just dies on the vine. It's the same
Well, I
result.
think dying on the vine means that there should be a hearing because the motion was to throw it out. And if a majority didn't say throw this case out, I think it should be taken up at the full task
Well,
force.
that's why I asked what the process was that had been operating for the past year, and you've been here for the past year. I haven't, as to what happens when an item comes from committee and gets decided on. And in the meetings that I have been here, it's been, do we accept the recommendation of the committee or not? Whether or not the respondents are here or not. And that's all that matters. And if there's no motion, then there's no motion.
Well, I think that what matters is also what my experience is over 20 years, and that is that the complaint committee would forward the question of jurisdiction.
But I understand that.
And I haven't been involved. I have never requested a subcommittee
but
hearing.
it's all what happened in the past year, because that's when this new process got put into place.
So we're talking that has been the practice, but it's not documented.
I don't know if it's I can't tell you. I can't answer that question.
So our meeting just ended because we don't have quorum.
1, 2, 3. We still have quorum.
Oh, we still have
So,
6. Okay.
I didn't see it.
Move to it. Somebody move to adjourn.
Move to adjourn.
Second.
By Rise.